Anyone who's not done an audio video check, please turn on a video and I will call on them. Last call for audio video check. Please turn on the video and raise their hand and I will call on them.
Basic, is my sound okay?
Yes, sir. You're good to go.
Thank you.
John, has Commissioner Brown Bland checked in with you?
Yes, sir. She was just here.
Okay, great. Joanne, you ready to go? All right, that's great. Good afternoon, everyone. Let's come back to order and pick up where we left off Friday afternoon. I hope everyone had a good, restful weekend, and we'll see if we can get through the home stretch here. One administrative matter first, Mr. Mehta, we just uploaded an order allowing the company's designation of late file exhibit number 79, so that motion is granted. Let me also alert you to a technical issue that we think is going to be okay. The proposed Sierra Club exhibit number 2, which was the EIS for the Mayo plant, We can't handle that in the clerk's file as a single document. So it's going to be, when it's brought into the record, it will be in 4 parts in the clerk's filings. The page numbering, though, will maintain the integrity of the original document. So if you go to STAR and look for the document in the clerk's records, don't freak out that it's in 4 pieces. The page numbering will still have the same exact sequence as in the copies that were served on you originally. So anything else administrative? Mr. Robinson, anyone else? Anything else?
Yes, Commissioner Clodfelter, Kamal Robinson. I just thought I would provide, if the opportunity is now, a status update on the company's late filed exhibits and where they are in preparation.
I tell you what, let's do. Let's hold that, because what I'm going to do, Mr. Robinson, at the end is we'll, when we're done with the testimony, we'll close the record to live testimony, but we will hold the record open for late filed exhibits. And what I'll ask Mr. Mertz to do is confer with you and other parties who are responsible for compiling late filed exhibits in a day or so after we conclude the live testimony, just to make sure we got a complete record of that. And that way we can do it all at one time when we're done.
Perfectly fine. Thank you.
Great. Okay, we're back. Ms. Bednarsik, welcome back. And we are now on commissioners' questions, beginning with Commissioner Brown-Bland.
Yes, Ms. Bednarsik, I just have one request. It's similar to the one I made in the DEC case. Could you identify in a late filed exhibit those persons in any way affiliated with the company, whether it's third parties, contractors, DEC or DEP, who you contacted to aid you in your learning about the DEP's historical CCR handling related to DEP's coal-fired plant sites? If you could do that for me.
Yes, Commissioner Brown-Bland.
All right, and that's all I have. Thank you.
All right, thank you. Commissioner Gray.
No questions.
All right, Chair Mitchell.
I do have a question for you, Ms. Bednarsik. Thank you for being back with us again this afternoon. I will keep my question short. In 2009, Duke and Progress, not affiliated at that time, made a presentation to the commission during a Monday morning staff conference hearing regarding their respective dam safety procedures. The transcript and documentation associated with that presentation were filed with the commission in docket number E100 sub 23A. And the date that presentation was made, I think it was in February 2009. And my notes don't reflect the actual day, but it was February 2009. But the representative who spoke for Progress was Charles Gates. In your research and sort of the historical record associated with the DEP facilities, did you have an opportunity to speak with Mr. Gates?
No, I did not directly with Mr. Gates.
Okay. Well, in his presentation to the commission, Mr. Gates referenced, and this was in response to a question that he was asked by Commissioner Joyner, and she was sort of discussing the conversion from wet storage to dry storage. But Mr. Gates discussed a 20-year plan that the company had laid out for handling ash. Do you know, do you have any idea what the 20-year plan is that Mr. Gates was referencing?
And Chair Mitchell, and so I think I wrote down the date of 2009. I do know that there is a 2006 20-year plan, and I discussed it with Commissioner Clodfelter in my direct testimony that we are going to be providing as a late filed exhibit. So I have seen the 2006 20-year Duke Energy Progress plan relating to ash storage, what the company at that time was looking at to make sure we continue operating our plants in the future. So that is going to be part of that late filed exhibit.
Okay, perfect. Well, then you've answered my question. Thank you very much. I appreciate it. I have nothing further for the witness.
All right, Commissioner Duffley.
I have no questions.
Thank you. Commissioner Hughes.
Yes. Can I just ask you a little bit about the risk assessment processes that you personally are using in your work now, and how it might have differed from some of what you might have researched in the past. Could you briefly describe some of the key ways that you quantify risk now for the decisions that you're making day to day on your cleanups? And you know, a lot's changed in the last 20 years. Could you just talk a little bit about one or two of the changes? And I know we could make this a really long answer, so you can give me the medium short version.
Of course, Commissioner Hughes, I'll try and give you something short and sweet. Of course, we look at cost risks based upon market conditions whenever we are executing a project, and making sure that we have enough contingency in our funding requests as we go for funding, and going for how much a project is going to cost. And so we do look at, we get an idea of how much we've seen fluctuations, or based upon past experience with executing a work. So of course that risk gets built into our contingency. Another thing for execution of projects, we look at moisture content of the ash. We look at weather delay. So that's the actual funding and execution of the work. We also, of course, take a look at risk at a high level for environmental health and safety risk, as well as corporate risk. So those items are very similar to what the Attorney General's office had, that one document that she referenced that showed a risk matrix. So we still look at things such as environmental and regulatory risk, looking ahead as to what, if there's any new rule changes, what that might be, and making sure we keep an eye on any potential rule changes. We look at reputation, we look at our communities, we look at costs, of course. So across the board, we do keep all of those same type of factors that were shown in that one exhibit that the AGO's office went through with me for risk at a corporate level type of a risk. The project execution, it's more of the lessons learned that we have seen for executing the project. The things that we have, all the lessons learned in past projects get built into building those new projects and execution. I'm hoping that answers your question.
Yeah, no, I think that for today. And how about when you've looked at some of the work that was going on 20 years ago? Was it the same forms, the same scale? What were some of the differences in how risk was, your predecessors were quantifying risk?
So I would say 20 years ago, it was different. It wasn't the form that we use today, not as much of a qualitative type of Excel spreadsheet, I would say, that I noticed that came around probably, I can't remember how many years ago, where we took more an Excel spreadsheet, looking at it and laying it out that way. What I saw from the historical documents is that there was an idea of we have regulations that are coming in the future, so let's continue to keep an eye on it. Let's make sure that we are involved in the process, so we see things that are going along. Of course, once we have that regulatory certainty, that's when we would move forward. But we wanted to make sure that we were involved in the process, so that we knew and we could do some planning in the future of, if a regulation came forward in one way, that we're not just sitting back and going, now we need to figure out what the game plan is. There's a couple of different ideas, so that as regulations change and move, and that we are ready to move forward once we have that certainty. So I do see that not as much of the Excel spreadsheet written out in numerical form, but in the documents I see that in there, that we wanted to make sure that we saw what was on the horizon and that we were tracking it appropriately.
Okay, no, that's helpful. No further questions. Thank you.
Thank you, Commissioner McKissick.
I believe with the witness's testimony in the prior proceeding, as well as the testimony she's provided in this proceeding, the vast majority of my questions have been answered. But I appreciate her directness in terms of responsiveness to the issues that have been raised by commissioners as well as attorneys. I thank you.
Ms. Bednarczyk, I've got a few stray loose ends going back through my notes. You told us earlier that the current situation with respect to all of the what I'll call old impoundments, I think that was the phrase Mr. Mehta used. I call them inactive, but they were not receiving new coal ash, let's call them that they all had a vegetative cover on them. And I did not ask you at the time, was that vegetative cover a natural revegetation or was that all planted?
Commissioner Clodfelter, I did go back and make sure I got the right information. Also about dewatering, I know we had a conversation about that. For all of the inactive ponds, once they stopped receiving coal ash, of course, we did not have sluicing of the water into the ponds, remove the channelization of the stormwater to those ponds. So they just received rainwater and they would have naturally decanted out through the NPDES. So we did not do like we're doing today, that the last couple feet in our current ponds, we're doing dewatering. And that's what's written in our SOCs, our special orders of consent is that last 3 feet. But the rest of it down to that 3 feet was decanted naturally. And that's what it appears has happened to those inactive basins, is that they decanted naturally over time. And then for the vegetation that's on top, it was not something that we placed there over time. It was vegetated through just throughout the years. But of course, we own that property. We maintain that property. And we always looked at that area as potentially other areas if we were to do maybe a landfill on top of those old basins. And those old basins were part of the plan to do in our final closure.
Okay, thank you for that, and thank you especially because it helps me bring your testimony and Mr. Karen's testimony into sync. So I appreciate that answer. With respect to the 2006 plan that you were discussing with Chair Mitchell, that you will be providing as part of the late file exhibit of the historical documents, was that I missed it? Was that a 10-year plan or a 20-year plan?
So the Duke Energy Progress Plan was a 20-year plan.
It was a 20-year plan. Okay.
I think it was until 2025 time period.
Okay. Was there any earlier iteration or version of that prior to the 2006 version?
We were not able to locate a prior version.
Right. I want to ask you about a document that I had some conversation with Witness Wells about in the DEC case. And in the last DEC case in 2018, it was marked as Attorney General's Karen Direct Cross Exhibit 3. It was the Duke Energy Carolinas 2007 Environmental Management Program for Coal Combustion Products. Have you ever heard of that document or seen it before?
I have heard of that document. I have seen it. I don't know if I can put my hands on it very quickly, though.
Well, my question to you really is you don't have to have the document. I just was curious, as in that general time period, let's just say sometime prior to 2010, was there anything similar for Duke Energy Progress? This would have been at a time when the companies were still independent. And I'm really just trying to find out, was there a similar policy document for Duke Progress?
As I sit here today, I can't recall one that I have seen, but I'd have to go back through my files just to make sure. But as I sit here today, I can't bring one to mind right now. Okay.
Well, I assume if you had anything close, it'll probably appear in the group of historical documents that you're going to be filing. So I'll leave that for now. Let me ask you one more question about a document. And this one, I think we alerted your counsel that I might have a question or two about it. They're high-level questions. They're not going to be details. It was the 2012 Plant Retirement Comprehensive Program Plan that was marked in the prior Duke Carolinas case as Attorney General Doss Cross-Examination Exhibit 1. Do you have access to that document, or you have had access to that document?
I have the document in front of me.
That's great. Well, on the cover page of the document, it says it's revision number 1. And my question was, does that mean there was an earlier iteration of this on original?
Yeah, so this document was based upon a document that was prepared by Duke Energy Progress prior to the merger. So there was a document, it looks surprisingly similar only for the Duke Energy Progress sites that has a 2011 date on it.
That's great. Thank you. And I assume, can I safely assume that that document will also be in the package of historical documents that you'll be supplying as the late file exhibit?
I believe we provided that in a data request in the past, and if not, we can include that.
Okay, thank you. Do you know that whether prior to the 2011 version, was there any earlier iteration prior to 2011?
We have not been able to find anything prior. The 2011 one, which I have in front of me, it says revision 0 on it.
Okay.
And it was whenever that team was brought together to start working on a guidance document for plant demolition itself.
Was this annually updated? So would there be a 2013 version and a 2014 version and so on?
So the 2013 version, we haven't found one that says on the front page 2013, but there is a document that had a revision date in 2013. I think they changed the year to say a year forward. So there is one from 2013, October 2013 was signed off. And we still create similar documents, of course, without the coal ash basins for our plant demolition program now. Is underneath me. So I know we still follow generally the same process of yearly looking at what our plans are for the next couple of years, and also making sure that we have clarity for funding for the next year, and then a good game plan for the next couple of years. But every year it's updated.
Thank you. I assume, would I be correct in assuming that after 2014, the coal ash piece of those was pulled out and dealt with separately due to CCR regulations and the CAMA requirement to develop plans pursuant to CAMA and CCR?
Yes, the following document, which was October or December 2014, did not have coal ash in it.
Okay, thank you, Ms. Bednarczyk. I only have the 2012 one, so that's the one I'm going to be referring to, and until I see the other one later. On page 20 of the document, under the heading Annual Funding Requirements, Authorizations, and Gate Reviews, there is a chart there of some cost estimates. I'm not going to go into the detail of those cost estimates. I really just want to know, what was the source of those numbers, if you know? Were they based on third-party decommissioning studies? Were they internal estimates? How were they produced?
So I had discussions specifically with Mr. Zarzar about this to make sure that it follows what we do today, which is that the initial dollar amounts are based upon those decommissioning studies done by the third party. So that is specifically for the Legacy Progress Carolinas items. It's very close, but of course, as we move through, we use that as our basis until we get more information as we start moving through the process. If we have a cost per ton or a labor rate that's a little bit different, then of course we would modify those. But that's the same process we use today, that we start off with those decommissioning studies and the dollar amounts, and then modify them as we go through the years, as we get bids in, as we get more information.
I understand. Thank you. Do you know whether these estimates on page 20, were these the source estimates that were used when the company in the 2011-2012 general rate case made a request for a specific allowance and rates of an item of an amount for coal ash basin closure? Were these numbers the source of the sizing of that request?
Unfortunately, Commissioner Klopfelter, it may have been a better question for Mr. Spanos. Okay. And I know that he looked into on the Duke Energy Progress side. I don't know if specifically it was this, but I do know, of course, those decommissioning studies were provided and utilized in those cases. Right.
Thank you. Mr. Spanos told me they were in the record of the 2011 cases. I just didn't go into the record over the weekend. So that's my homework assignment. So last thing I have for you is, and thank you for the answer you gave, Mr. Marzo, on redirect about my earlier line of questioning when you were here earlier about activities beyond the compliance boundary. I'll call it that for shorthand. And I appreciate your answer. I understand your answer. I'm going to now make a modified request for a late filed exhibit. It's not the same request as earlier. This is a modified request. for the activities you're presently conducting outside the compliance boundary. And that would include groundwater monitoring outside the compliance boundary, assessment, and any corrective action you're undertaking outside the compliance boundary at Roxborough, at Sutton, and I can't remember if there was a third plant, but we'll throw it in if there is a third or a plant. I would like to see a cost breakout just for those costs. I understand your earlier answer is that those might be different than what the cost would have been just under the 2L rules. I appreciate that. I'd like to just sort of see a breakout of your actual costs for those activities conducted outside the compliance boundary.
So Commissioner Clodfelter, we'll take a look at that. I'm not sure if we'll be able to, because of course, as we install wells, monitor those wells, all of those purchase orders that go in are all the wells at one time, but we'll take a look at that and see what we can do, but we may not be able to pull them out, but we'll work with our accounting to see if we're able.
I appreciate that. What I would ask you to do is, as much as you can identify and segregate, let's see it. As I understand it, you're not doing any extraction within the compliance boundary. So if you're doing extraction, I assume that would all be outside the compliance boundary. And if you, for example, if you can break that out, if you can break some items out, but not all items, just whatever you can do, I would appreciate.
Yes, sir, we will do that.
Thank you, Ms. Bednarsik. I appreciate your time. And with that, we're at questions on the commission's questions. Speak now, anyone. Who'd like to go next?
Commissioner Clodfelter, I may just have one or two, but I would prefer to go last if there's others who have questions.
The public staff doesn't have any questions. Thank you.
The Attorney General has no questions. Thank you.
Commissioner Clodfelter, I guess I will go then. Ms. Bednarsik, just very quickly, I know that you just talked to Commissioner Clodfelter about the 2012 Plant Retirement Comprehensive Program Plan, and that you mentioned that you had discussed that document with Isa Zarzar, who's listed on the cover. And could you give some more context of discussions you had and the purpose behind this document?
The purpose behind this document is to lay out a kind of an overall program of demolition of the plant. So in the 2011, 2012 time period after the two companies merged, it was to lay out the demolition activities. And again, at that time, it did have a coal ash basin, the idea that we would cap those basins in place. And using the Weatherspoon closure document as our template, and it discusses that in that document. But really at a high level, what it's to do is to lay out the program for demolition, starting with taking down the buildings, how we would take down those buildings, not in the details of how we would take them down, but what we are looking at for the next couple of years for activities in order to move forward on demolition.
Okay, thank you, Ms. Bednarsik. And I noticed during the executive summary of that document, there is a short bullet on cost recovery. Did Mrs. Zarzar share with you whether or not he was the author of that, or if that is just information that was just included in this report?
That specific on cost recovery, he mentioned, was provided to him directly. And as you look into the subsequent, of course, the subsequent revisions, you see that going forward and asking for a deferral is discussed in there as well. So anything related to recovery, it changed after that document to look at and say, this is something we would look at in the future for deferrals.
And the cost estimates that you discussed with Commissioner Clodfelter near the middle to the back of the document, is it fair to say those are planning estimates? I mean, they're not what we would consider to be the detail you would use for a cost recovery type estimate. Is that fair?
So specifically for cost recovery, as I mentioned to Commissioner Clodfelter, that would be the demolition or the decommissioning studies. And then beyond that, of course, we have conversations even today with our rates and regulatory organization as we're doing our demolition work to make sure that they are aware of what those costs are once they're being executed, or if there's any changes to those costs. But for the first year, especially in that document, a lot of it is engineering and planning for the coal ash basins was those preliminary site characterization evaluations, which is what happened in the 2012 and 2013 time period.
And Ms. Darcy, one last question. I mean, is it fair to say, I looked on this document, one of the sections talks on page 7, for example, about legislative and regulatory expectations. Is it fair to say that Mr. Zarzar and the company, Duke Energy Progress at the time, was balancing a number of regulatory concerns as they considered decommissioning?
Yeah, so if you look at that page 7 on the document, it talks about environmental regulations and new initiatives, including cooling water systems, wastewater discharge temperature and chemical content, coal combustion residual management, and air emissions, regulations, all of that was on the horizon. It also has a section that talks about the taking away the retirement of the Weatherspoon, Cape Fear, Lee and Sutton coal plants associated with building of the new combined cycle plants and orders from the commission. So it's balancing a lot of different ideas. So it has a high level inside this document as to the things that the company was looking at.
Okay, thank you, Ms. Bendarsic. Thank you, Commissioner Clodfelter. I'm done with my question on Commissioner's questions.
Okay, I think we're at the point where we can entertain the motions relative to exhibits. So who wants to go first?
I'll begin. This is Megan Yost with the public staff. We would move that Bednarsek rebuttal public staff cross-examination exhibits 6, 7, and 9. In confidential Bednarsek rebuttal public staff cross-examination exhibit 8 be admitted into evidence as they were identified for the record.
And that 8 maintain its confidential status in the record. You've heard the motion from Ms. Jost. Is there any objection? The motion is allowed. Ms. Townsend, you want to go next?
Yes, please. We would move that the Bednarsek rebuttal AGO cross exhibit number 2 be admitted into evidence.
Hearing no objection, it is so ordered.
Thank you.
Ms. Crawley-Jones.
Yes, as we've discussed by agreement, the company has prepared a combined electronic document with page numbering for the entire document. We'll be refiling that in 4 parts with the page numbering, so all parties to the commission will have easy reference. So we would now move that Bednarsek rebuttal Sierra Club DEP cross exhibit 2 be moved into the record. And I guess one clarification, are we still using the hyperlink? And would you like also hard copies filed of the specific reference pages?
I think that would facilitate easy use of the transcript. And so, yes, please, we'll handle the hyperlink the way that you and Mr. Mertz and the clerk's office and the court reporter have worked out. But I think it would also help to have the pages that were specifically called out so that users who may want to read the transcript later, who weren't parties to the hearing, can do so conveniently. So let's do that.
So for the record, the EPA correspondence we discussed on Friday can be found at the new document PDF pages 498 through 514, and we will also file those separately.
That's great. Thank you, Ms. Crawley-Jones. You've heard the motion. Is there any objection? Hearing none, the motion is allowed.
And then we would further move that Bednarsek rebuttal Sierra Club DEP cross exhibit 3 be admitted to the record.
Without objection, it will be so ordered. Okay, Mr. Marzo, I think that leaves you.
Commissioner Clodfelter, I'd ask that Ms. Bendarsik's rebuttal exhibits 1 through 9 be moved into the record, as well as her supplemental exhibits 1 through 4.
All right, you've heard the I'm sorry?
Yeah, I also have 1 redirect exhibit to move, my redirect exhibit number 1.
Okay, you've heard the motion from Mr. Marzo. Is there any objection? Hearing none, motion is granted. Okay. Ms. Bednarsek, your ordeal is over. She's subject to recall.
She is, yes, Commissioner Clodfelter, she is subject to recall.
Okay, that's correct. I just noted that on my sheet, so we won't excuse her now. And we're with your next witness. We're ready for your next witness.
I will turn it over to Mr. Mehta.
Okay.
Thank you, Commissioner Clodfelter and Mr. Marzo. The company now calls Steve Fetter.
Mr. Fetter, will you please raise your right hand? Do you solemnly and sincerely affirm that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay. Mr. Mehta?
Mr. Fetter, would you please state your name and business address for the record?
Stephen M. Fetter. And I have an energy advisory firm, Regulation Unfettered, located at 1240 West Sims Way, Port Townsend, Washington, 98368.
In what capacity do you work for Regulation Unfettered?
I am a president of my own energy advisory firm.
Mr. Fetter, on May 4th, 2020, did you cause to be pre-filed in this docket rebuttal testimony consisting of 26 pages along with attachment A?
Yes, I did.
Do you have any changes or corrections to your pre-filed rebuttal testimony?
No, I do not.
And if I asked you the same questions here today, would your answers be the same?
Yes, they would.
Mr. Fetter, did you also prepare a summary of your testimony, which has previously been provided to the commission and the parties?
Yes, I did.
Do you have any changes or corrections to your summary?
No, I do not.
Commissioner Clodfelter, I move that Mr. Fetter's pre-filed rebuttal testimony, including attachment A, and the summary of his testimony be admitted into evidence and copied into the record in this proceeding as though given orally from the stand.
You have heard the motion. Is there any objection? Hearing none, the motion is granted.
Thank you, Commissioner Clodfelter, and Mr. Fetter is now available for cross-examination and commissioner questions.
Okay, Mr. Grantmeyer?
Good afternoon, Mr. Fetter. This is Bill Grantmeyer, Public Staff. If you could turn to page 7 of your testimony.
I am there.
And you see chart 1 is rating categories. Will you acknowledge that Duke Energy Progress secured credit rating is A3?
Well, on this chart, I indicate the unsecured rating, the issuer rating, but I believe it's 2 notches higher on the secured.
Okay, and the their issuer rating is A2, is that correct?
Yes.
And Duke Energy Progress has a stable rating from Moody's, is that correct?
Yes.
And Duke Energy Corporation is a AA1, is that correct?
At Moody's.
Yes, and which is 2 grades lower than Duke Energy Progress's issuer rating. Do you agree with that?
Yes.
Now, I would ask that bring your attention to Public Staff Cross-Examination Exhibit number 96, which is...
Could you tell me which one that is?
It's the one that lists all the Woolridge Proxy Group, all the credit ratings of a bunch of electric utilities, the operating and the parent companies. It's on page 3110.
Okay, I'm not.
Commissioner
sure.
Clodfelter, on the, I think Mr. Fetter was asked questions about this the last time and had trouble uploading it because it's grouped with a whole lot of other public staff exhibits. If you don't mind, I will just email him that specific document. I think it's only 1 page, so it won't take.
Yeah, it's 2 pages, yes.
A couple pages. I'll do that right now.
Let's be at ease for just a minute here.
Well, we're having a technical issue, but I will solve it in just a second. Sorry about that.
Mr. Fetter, do you have a notebook of the public staff's proposed exhibits?
I have about 40 notebooks
Okay.
in my house, in my condo.
I think the issue may be that the public staff, some of the notebooks are tabbed and some are not. It may be possible for Mr. Grantmeyer to call out a page number because I believe they are consecutively paginated. If you
This is
right notebook.
page
Okay, I think
3110.
I think Mr. Mehta has succeeded.
Great.
So I will open that document now. It will take a moment for my antivirus to make sure it's safe. Okay, I believe I have both pages, Council.
And you see at the bottom, now this is a list, would you agree, of electric utilities, the holding companies and the operating companies for a significant group of electric utilities. Would you agree with that?
Yes, sir.
And you see in the middle of, or about 2/3 of the way down page 1, Duke Energy Progress LLC has a Moody's issuer rating, like we said, of A2.
Yes, sir.
And would you, subject to check, would you accept that there are only 11 operating companies on this 2 pages that are A2 and 5 that are A1?
It appears from the notations at the bottom. So the document will speak for itself, but I'll accept that the quantification was done appropriately.
And you would accept that if we divided the 16 companies that are A1 or A2 by the 78, that the Duke Energy Progress is in the top 21% of the companies, the operating companies listed?
Yes, it would appear that that would be an appropriate measurement.
Now, I'm not going to ask this as a cross-examination exhibit, but earlier, will you accept that in that 86.7% of all of Duke's Progress's long-term debt were first mortgage bonds that they were secured?
Unless there's a document showing that, I don't know the percentage off the top of my head.
Okay. Now, are you aware that in late August of this year, that Duke Energy Progress issued $600 million in 30-year first mortgage bonds at a rate of 2.50%?
I might have heard that during earlier testimony, but I didn't, of my own accord, confirm that information.
Now, if you would turn to page 8.
Page 8 of mine?
Yes.
I'm there.
Now, you talk about you want to maintain it. You should always try to maintain an A rating for utility companies. Is that correct?
Yes, I say either work towards an A or maintain an A if you have it.
Well, if by chance Duke Energy Progress was downgraded 1 grade, its issuer rating would be A3. Is that correct?
Yes, it would.
And it would still be in the A range. And its secured rating, if it was downgraded 1 grade, would be A1. Which
yes.
Is still, okay.
I'm sorry, were you finished with the question?
I hope so.
Okay, yeah. It would be, if it continues as the norm, it would be 2 notches higher for the secured debt.
Now, I turn you to page 19 of your testimony. We'll come back to some pages.
I am at 19.
And on lines 5 and 6.
Yes.
You state that Mr. Lucas acknowledges that it is possible no imprudence occurred back when the company's decisions were made. You remember saying that?
Yes, I said that as noted on that page.
Now, don't you remember reading in Mr. Lucas's, and I won't go through all the pages, where he also said that based on the groundwater exceedances back in the early 80s, the company should have installed more monitoring wells. Don't you remember him saying that?
No, I'd have to go back and review his testimony.
Okay. But you would agree his testimony says what it says?
Oh, of course. He says what he says, and I say what I say. And I didn't see that. I think staff noted that they couldn't find any imprudence, couldn't do a prudence review, and that any quantification of costs would be speculative. And that's what struck me as standing out as compared to the hundreds of testimonies I've read in other proceedings.
But you would agree that when he keeps pointing out that there were 7,411 groundwater exceedances, that emphasized, at least in his testimony, that there was imprudence in not going ahead and installing those monitoring wells.
I do not believe he found a conclusion of imprudence, but his testimony will speak for itself.
Now, excuse me just a minute. On page 11, will you go back to page 11, please? This is your testimony?
I am there.
Now, on page 12, you talk about how important it is for a significant degree of predictability.
I know I say something like that. Could you direct me on page 12?
Line 12, right at the end of that sentence there.
This is page 12, line 12, you're saying?
I'm sorry, page 11, line 12. I'm sorry.
Okay. Yes, I'll read the sentence so everyone's aware how it fits. Utility investors understand and accept the role of extensive regulation, but they seek from the regulatory process decision-making that is fair with a significant degree of predictability.
And wouldn't you agree that the Commission's Dominion Energy North Carolina, February 24, 2020, provides predictability for potential investors?
No, I think the investors were relying on the statement in 2018 in the DEP, the last case, along the lines of the Commission will address the appropriate amortization period in DEP's next general rate case, and unless future imprudence is established, will permit earning a full return on the unamortized balance. So I think that's what drew their attention, greater than a statement in a Dominion case, which dealt with a much smaller entity.
But the Dominion case is the most recent case. So when, if I was an investor, I would look at the most recent decision for guidance.
Well, I think investors would look most likely at a specific statement made about DEP as opposed to a statement made about another entity that operates mostly outside the state of North Carolina, has a smaller footprint in North Carolina.
Now, you would agree that if they were arguing or trying to prove imprudence, it would be almost impossible to reconstruct what the costs were 40 years ago.
Well, I think I gave it an example last time that I came onto the Michigan Commission in 1987, and one of the duties of the three-member commission during my 6 years on the commission were to make prudence, imprudence determinations about a nuclear plant that was abandoned years before I entered my tenure on the commission. And it was not easy. It took about 5 or 6 years, but we came to a determination of when prudence ended and imprudence began. So I acknowledge it would be a very difficult process to make judgments about imprudence 40 years ago.
And the one you did in Michigan, how many years earlier was that plan abandoned?
I believe it was abandoned. This would be just a guess, maybe 3 to 5 years before I entered my time on the commission.
Commissioner Clodfelter, I would ask that the Public Staff 96 cross-examination exhibit be marked as Public Staff Fetter Rebuttal Cross-Examination Exhibit number 1. I failed to do so.
All right, Mr. Grantmeyer, it will be marked as Fetter Rebuttal Public Staff Cross-Examination Exhibit number 1.
Now, on page 21, you discuss the Georgia Power decision. Is that correct?
Let me get there. Yes, I do.
And now in the Georgia, you're aware that Duke Energy Progress pled guilty to 4 criminal negligence in regard to the Clean Water Act. Are you aware of that?
I know that there were some criminal charges agreed to.
And were there criminal charges agreed to in the Georgia Power case?
Not that I am aware of.
Now, with regard to credit rating agencies, in the Duke case, Duke Carolinas, we went through 4 riders that Duke Carolinas had, and you said those are looked on favorably by the credit rating agencies. Do you remember that?
Yes, I noted that riders have become extremely popular across the regulated utility universe over the last 15 years or so. And so, yes, those are credit positive and also becoming very common across the industry as norms.
Now, will you accept subject to check that Duke Energy Progress has those same 4 riders?
I will accept that subject to check that they exist for DEP.
And don't you agree that the stipulation that Duke Energy Progress entered into with the public staff as to the ROE, as to the capital structure, and as to the $1.3 billion for both Duke Carolinas and Duke Energy Progress being a deferral, all those are credit positive, considered credit positive by the rating agencies?
Yes, as the agencies have noted, that's a positive first step, and they're waiting on the coal ash decision.
And the storm securitization, you said you worked on those before when you were, I believe, with Fitch. That is, and if they file a petition and get approval, that's considered credit positive, isn't it?
Yes, I view securitization as good for investors and good for customers.
Now, if we could turn to page 24.
I am there.
And in this, you're talking about in this, you say on line 13, you seem to say that if the public staff prevails on this COLAF issue, it would lead to a credit downgrade. And then later down on line 16, you say Moody's has stated a weakening regulatory support could lead to a downgrade. Now, isn't it true you really cannot predict with any certainty what will happen with regard to credit downgrades or upgrades based on this the commission's decision?
Okay, that's a 2-part question, so I'll answer 2 parts. I did not say merely the coal ash decision. At that time, Mr. Hinton was advising several steps below what has been agreed to in the partial settlement, and I was making a statement that if this public staff position was adopted on the quantitative and the qualitative side in all aspects, including ROE, cap structure, the return of the tax reform monies, as well as coal ash, then it was likely there would be a downgrade, or I said undoubtedly would lead to a downgrade. As we know, several of those issues are off the table, and so depending on the severity of the coal ash decision, I'd say there could be a downgrade, there might be a change in outlook, or there might be no action other than a firming up of DEP's credit profile or a strengthening or weakening of that profile.
Now, if we could turn to page 25, and
I'm there.
Towards the bottom of your page 25, you're talking about the difficulty borrowing funds during the COVID, that 60 or 90-day period that the bond market was unstable. Would you agree to that?
Yeah, there was a period in late March where basically it froze up, which led the Fed to step in and put enormous amount of funds. I think in an unprecedented amount of funding support to the debt markets.
But you would agree that the last pandemic was over 100 years ago?
Let me see, 1918. So yeah,
that's 102.
Just over 100 years ago.
Okay, and the Great Recession that we had in 2008, 2009, the Great Depression was about 70 years prior to that. Would you agree to that?
I will, subject to check, I'll take you.
Okay. Okay. Now, down on line 18, you talk about Entergy not being able to borrow money. Do you happen to remember which Entergy company that was that could not borrow the money?
I was referring to Carl Newland's testimony. So I don't recall whether he was talking about the parent or Entergy New Orleans. I think he was talking about the parent in his testimony, but the testimony will speak for itself.
But you would agree that Public Staff 96, Public Staff Feder Rebuttal Cross-Examination Exhibit 1 lists Entergy Corporation as a BAA2 issuer rate.
Which document? The first one you showed me today?
Yeah.
I closed it out, but it says what it says.
Okay. And one of their operating companies is Entergy New Orleans, which has a BA1, which is not even an investment grade rating. Would you accept that subject to check?
Yes, I believe that's where Entergy New Orleans sits. But looking at this, I believe Mr. Newland talked about the parent Entergy Corp at BBB.
And you would admit that Entergy, the parent corporation, is significantly lower than Duke Energy Progress's credit rating.
Yes, it is in the BBB category.
And I now go to Public Staff Document 102, which is on page 3120, and ask that it be identified as Public Staff Feder Rebuttal Cross-Examination Exhibit number 2. This is the stock price close.
It will be marked as Feder Rebuttal Public Staff Cross-Examination Exhibit 2.
Is this Public Staff 102 at the top?
Yes.
Okay, I have that.
And I sent to your attorneys about a week ago some additional information. Was that ever forwarded to you on this exhibit?
What can you describe the additional information?
Where it has the Dow Public Utility Index.
Is this page has some notations on it?
Yeah, that's scribbling. That's mine.
I have it.
Okay, very good. And Do you remember when we testified on Duke Energy Carolinas, you said that a comparison to the Dow Public Utility Index would be a better comparison than the S&P 500 index? You remember saying that?
No, I don't remember saying that.
Okay. Anyway, will you accept from February 24th, the day of the the Dominion Energy North Carolina order was issued, to March 3rd, that the decrease, subject to check on your math, for Duke was 6.54%?
I'll take the number as calculated. It will speak for itself if it's
Okay.
wrong.
We could agree that the commission has some excellent accountants that could verify all this. And the Dow Utility Index declined 6.27%.
That's what this says.
And the S&P 500 declined 6.91%.
That's what this says.
Okay. About a week ago, I forwarded to your attorneys the value line for Duke Energy Corporation dated August 14, 2020. Do you happen to have that?
I have what I believe, is this a value line document?
Yes.
Yeah, I've never used value line, so I wasn't sure what it was, but I did receive this document.
Okay, since you never use it, I'll go through it very quickly. You would agree that this is a service that some investors use for information?
I believe mostly equity investors would use value line as opposed to debt. Debt investors would use it less so, but equity certainly, yes.
And towards the bottom, on the bottom right-hand side, there's two columns. They talk about what's going on with Duke Energy Corporation. The commissioners don't have this. It's just you, I, and the attorneys. And I'm not going to introduce it into evidence, but will you accept, subject to check, that in the discussion about Duke Energy Corporation, they never mentioned coal ash in this value line?
Is there a date on this, when this was?
August 14, 2020, in the bottom right-hand, very towards the bottom, about an inch from the bottom.
Okay, I see that, yes. I mean, I haven't read it through, but what you've highlighted doesn't show coal ash.
Okay. Now, I would ask this next exhibit, which was public staff potential cross-examination exhibit 142, be identified as public staff Fetter rebuttal cross-examination exhibit number 3, which is the Form 8K filed by Duke Energy Corporation on September 9, 2020 with the Securities and Exchange Commission. Do you have that document?
It will be marked as Fetter rebuttal public staff cross-examination exhibit 3.
Yes, I believe I have that one.
Now, I'm going to try to go through this fairly quickly. Would you turn to, at the bottom, it says 4259.
I have 4256 at the bottom of what I received.
Yes, and 3 pages later, or 4 pages later, it'd be 4259.
I just have 2 documents. One is 4256. The other one says 4312.
So you did not get the full document. It's about 70 pages.
I may be able to find it in my emails if it's important to locate all the pages. Or maybe Mr. Mehta can send me the whole document again.
I'll be glad to send the whole document again. I think perhaps what Mr. Fetter did is copy, Mr. Grantmeyer, some highlighted page that you had towards the end of the document.
Yes, that's what I did. I copied for this hearing on Cross the highlighted page.
I'll just go ahead. It's just so it's easy to find. I will go ahead and send the entire 70-page document right now. And it is on its way.
Okay, I will be opening it now. Okay, I have it open, and if you give me the page number again, I'll search for it.
4259.
Okay, Council, I am at 4259.
And you would agree at the top right-hand corner, it states that this is Duke Energy Investor Update, September 2020.
Yeah, yes, it does.
And if we could go to, I'm going to go through a number of pages here. We hopefully very quickly. On 4263.
I'm skipping down. I am at 4263.
Is yours, does it show the highlighting? You don't have is it in color or just black and white?
Mine is black and white, and sometimes the highlighting shows up as, a little darker. I don't think I have any highlighting on this page.
Okay. Well, at the top, you will agree it has our long-term investor value proposition.
That's what the top says.
And then it goes on to talk about 6 categories. And if I'll just read them quickly, and if you could acknowledge that's what it says. First on the top left is scale owner of premium utilities.
Yes.
Then it talks low risk regulated business.
Yes.
Well positioned for energy transition to renewables.
Yes.
Strong regulated growth outlook.
Yes.
Delivering on annual earnings guidance.
Yes.
And history of major project execution and prudent management.
Yes.
Now, you would agree that those are all factors that investors consider? Or many
yes.
of them are factors?
These among others, but these would be considered.
And if we could move to page 4273.
Okay, I'm going down to that one. It's going a little slowly because of the chart heavy pages.
Mr. Graham, I'm sorry, could you give me that page number again?
4273.
Thank you.
I'm going to search for it because it's going very slowly with a thumbing down. Okay, I am at 4273.
And at the top, it states Duke completed its portfolio transition ahead of peers. Does your page say that?
That's what the title says.
And you would agree, as you glance at it quickly, on the left, it talks about current industry themes, correct?
Yes.
And divestiture of merchant businesses, that's one thing that, and Duke says on the right, they announced the exit from Midwest Generation in 2014.
Yes.
And isn't that positive from an investor standpoint that they got out of the merchant business or a lot of the merchant business?
Well, from a debt investor, it certainly is. From an equity investor, I think they have to make a determination whether that would have been a profitable enterprise.
And in regulated businesses, M&A, they announced the acquisition of Piedmont in 2015. Electric utilities purchasing natural gas utilities is considered a positive for electric utilities if the transaction is done properly.
Well, I think every transaction like that has some people think it's a positive and others who are concerned about any increased risk. So I can't, sitting here, offer a view of how debt or equity investors would view that line item.
Okay. And then it talks about divestiture of international businesses, and they got rid of the international businesses in 2016.
I think that's usually viewed as reducing risk because international regulation, where it exists, is usually a little more volatile than in the United States.
And at the very bottom, focus on O&M cost management. It says kept O&M flat since 2016.
That would usually indicate that they're beating inflation, which has been pretty low, but being flat, even in the face of low inflation, it would be a good direction to go.
Now, at the very bottom, will you agree? It says today's Duke Energy is a well-run electric utility, regulated electric and gas utility.
That's what it says.
And that would be positive for potential investors, would it not?
Yeah, that would be positive for both debt investors and equity investors.
And let's go to page 4281.
Okay, I will search for it. 4281.
Yes.
Okay, I am at that page.
And this is the one that states at the top, strong track record of performance.
Yes.
And the first line states, met annual guidance in 7 of the last 8 years while exiting businesses with volatile earnings. And you would agree that meeting guidance is looked favorably by the investment community.
It shows that management is accurately predicting in 7 of the past 8 years. It's always good for management to be on top of the enterprise, but of course we don't know. If you properly identify guidance in a negative direction, it's a positive that management understands it, but the guidance itself may not be positive. But like I said, management being on top of it 7 of the 8 years looks pretty good.
And the third one down, it says earned at or above allowed ROEs on a consistent basis. That is credit positive, isn't it?
That would be viewed positively.
And if we could go to page 4284.
Okay, I'll search for it. Okay, I'm there.
And it says with 2020 additional O&M cost savings well underway. Is that the title?
Yes.
And the first bullet there is highly confident in achieving 350 to 450 million reduction in O&M and other expenses mitigate 2020 headwinds. Isn't that credit positive that they've been able to have an O&M reduction?
Yeah, that would be positive.
And also about 2/3 of the way down, it talks about lower interest expense due to well-timed capital market transactions. Isn't that credit positive?
Yeah, that's a good thing.
And going to the next page, which is 4285.
Okay.
Again, they talk about that little box up there near the top, highly confident in achieving the 350 to 450 million reduction in O&M and other expenses in 2020 to mitigate COVID-19 impacts.
What was the date of this document? I didn't notice.
It's September 2020.
Okay, and so now you're asking about the box, and I'll read it to myself. Okay, and the question is?
Isn't that credit positive that they were able to mitigate COVID-19 impacts through their debt reduction, O&M reductions?
Okay, yeah, I mean, as they stated, highly confident. I think as we've seen in the past week, the full extent of the COVID-19 impacts may be greater than might have been predictable in September, but at the time they were highly confident that they could deal with what was to come.
Now, we're going to move on to what they call the balance sheet section. They talk about, if you would go, there's only 2 more of these pages, so that's the good news. 4312.
4312. Searching for it.
And this is the one on liquidity.
Okay, this was the one that was clearly highlighted. Yes.
Okay. And you see this is Duke Energy Corporation.
Yes.
And they talk about available liquidity June 30, 2020 being
yes.
$8.7 billion.
That's what it says.
And it talks about the master credit facilities. I believe it's $5.892 billion. Is that correct?
That's what it says.
And then there's also remaining availability from equity forwards, which is $2.579 billion.
That's what it says. That's what it says.
And you would agree all of those are credit positive?
I mean, I'd be guessing. Clearly, Mr. Young, Mr. Newland, probably even Mr. DeMay would have a view of this, but it seems like a lot of money available liquidity.
And liquidity would be important, such as when the COVID pandemic for the 60 or 75, 90 days there, when they needed some temporary money. Isn't that what basically liquidity is for temporary needs and emergencies?
Yes, and as I said, in fact, I think in answering Commissioner McKissick last time, we don't know what the future holds. So having liquidity is a good thing, and hopefully will be enough to deal with any negative events to come.
Now, this will be the last page. We'll go to 4316.
Okay, let me try to get there. Okay, I'll see if it goes fast enough thumbing down. Okay, I am at 4316.
And you can see at the top, it's small print, but it's the FFO debt for Duke Energy Progress. Do you see that?
That it appears to say that.
And this is December 31, 2019. It's hard to read, but it's...
Yeah, it appears to say that too.
And it also appears at the bottom, the FFO to debt at that time was 22%.
Mine is kind of muddled, but I'll accept that that's what it says.
Now, I know you haven't read this document, word for word. But would you be surprised to learn that this entire document, the words coal ash never appear one time?
You know, I'm not sure the full purpose of the document, so probably the three gentlemen I just mentioned in answer to a question or two ago, they're the ones who could offer a view of why coal ash is or is not in this document.
Okay, I would now move to Better Public Staff Rebuttal Cross-Examination Exhibit number 4, which is the potential cross-examination exhibit 140. Was this provided to you by your attorneys? It was a late filed cross-exhibit.
Can you describe what it is?
It's B&A Global Research, B&A Securities, their September 9, 2020 upgrading of Duke Energy Corporation.
Yes, in fact, this was the one you discussed briefly 2.5 weeks ago, and I thank you for providing it because it let me look into it in the whole scheme of Duke's equity. So I appreciate being given a heads up 2.5 weeks ago to let me research it.
Now, would you agree that the first paragraph?
Mr. Grantmeyer, let's get it marked.
We request that this be.
We will mark it, Mr. Grantmeyer. We will mark it as Federal Rebuttal Public Staff Cross-Examination Exhibit 4.
Thank you. I'm finally learning the correct wording. Thank you. Now, Mr. Fetter, I think it would be better if you just read into the record that first paragraph, coal ash pending and with tide beginning to shift favorably.
Coal ash pending with tide beginning to shift favorably, with Duke shares trading near its relative lows, paren -1% versus XLU since 2Q call, and more critically, a full -110% discount versus the group, close paren. We are upgrading to buy as we perceive a de-risked story, acute fears reflected. We see real reason for an inflection in EPS expectations with both positive regulatory backdrop on 21. It's a apostrophe 21 legislation and positive revisions to IRP CapEx, open paren, based on forthcoming reaction from NC/NCUC, close paren period. While pending coal ash rate case remains outstanding, open paren, and much anticipated cautious point, close paren, comma, we perceive an order similar to Dominion as quite likely. Open paren, after latest stakeholder discussions, close paren, semicolon. This would help firm up doubtful expectations. Further, comma, we anticipate existing settlements in the rate case to remain intact despite concerns otherwise too, period. Fears are likely at their worst heading into 4Q decisions in NC-NC positive EPS and regulatory data points arising into apostrophe 21, period. Expectations appear too at their low point, and investors seem to be missing the positive inflection from regulatory work Duke has been pursing. I think they meant to say pursuing. Bottom line, comma, analyst EPS expectations of -$5.40 on apostrophe 22 likely understate potential plus 14 billion in higher capex possible, open paren, tables below, close paren, and repositioned ESG trajectory, period. And that's the end of the first paragraph.
Which you would agree, in this paragraph, it says, even though they expect a decision similar to Dominion Energy, North Carolina, they increased from a hold to a buy.
This one analyst at B of A, or the analyst that heads the group, appears to indicate a hold to a buy. He of course is one of many analysts on Wall Street, but that's what he says.
And if we could go to page 4235, which is page 6 of this document.
I'm there.
And could you read into the record that heading rate case expectations, Dominion order likely, and just the first sentence, the last word goes into the next page. Or
do you want the entire paragraph?
No, just the first sentence.
Rate case expectations, coal ash Dominion order likely. We continue to expect Duke's rate case in the Carolinas to have a similar outcome to Dominion's coal ash order, with a 10-year amortization period and no return once past the deferral period.
And now we'll move on to potential cross-examination exhibit 141. And this is the September 11 follow-up by B&A Securities. And we would request this be identified as Feder Public Staff Rebuttal Cross-Examination Exhibit number 5.
It will be designated as Feder Rebuttal Public Staff Cross-Examination Exhibit 5.
I still don't have the wording. I'm going to catch on eventually. Okay. And do you have that open, Mr. Feder?
I have it in hard copy.
Okay. And don't you agree you've read this, haven't you?
Yes, because it came to me as part of your group of documents.
Okay. And you would admit, without reading the whole first paragraph again, it again affirms that they expect the Dominion order to be the progress in DEP order to be the same as the Dominion order. But even though they expect that, they're affirming their upgrade.
Well, from my experience on Wall Street, the most interesting thing I found about this was that 2 days after its initial upgrade report, it felt compelled to issue another report, and the first couple of sentences indicate why. It starts, "What is so controversial? ? Feedback on our upgrade." And then it says, "Following our earlier upgrade of shares from neutral to buy this week, we revisit the key debates among some investors." And so the fact that it issued another report 2 days after its initial change to buy, and those two sentences, says to me that they received a lot of pushback from Duke investors, which led them to feel they had to put out a new report. And that led me to go look at how the stock price did during these 3 days, September 9, 10, 11. And what I saw on the stock chart was concerning to me.
Well, didn't we have on September 9th, Duke closed at 82.59, did it not?
In fact, Council, I have a stock chart, which I hope you all can see. And you can see on, here is on the 9th. It opened, went down a little, then it shot up. The report came out at some point during the day, and then it plummeted in the last half hour of trading. And so it opened at 82.42 on September 9, and it closed slightly up at 82.59. The next day, the 10th, this is after the report was issued on the 9th, it opened down 37 basis points at 82.22, and it closed even lower at 82.00, which would be below where it opened on the 9th before the report came out. Then the new report came out sometime during the 11th. It opened at 82.07, closed at 83.03. So during this 3-day period, it opened at 82.42 and closed at 83.03. So that would be about 0.7% increase during the 3 days and after the two reports. And so certainly there was a lot of volatility up and down during those 3 days. And on two recommendations to buy, it went up just what I would view as a negligible amount. And it led me to do further research into what other analysts had said about this situation. And it's interesting because Wolf Research had put out a view on this case, and the person issuing it is named Steve Fleischman, and he goes way back on Wall Street, back when I was at Fitch. And in 2012, Institutional Investor put Mr. Fleischman as one of the 49 equity analysts in their Hall of Fame, the best analysts of all time. So I read with interest what Mr. Fleischman said about this case on August 11, 2020 in a Wolf Research report. And Mr. Fleischman, who had been at Merrill Lynch before the current, and he had been at B of A also before the current person who's there. And Mr. Fleischman said, if the NCUC uses the same logic on coal ash that it did in a Dominion order earlier this year, Duke would face an 8-cent headwind in 2021. Rating agencies have said no return on coal ash in NC would be credit negative. And then Mr. Fleischman indicates that Wolf Research, we see a downgrade of Duke as likely if that were to occur. So I put significant weight on the words of someone who's viewed as one of the best equity analysts of the last 40 years.
Now, will you accept, subject to check, that as of today, October 5, when I checked at 12:10 p.m., that the Duke Energy Corporation stock price at that time, a couple of hours ago, was selling at $91.84?
I will accept that, and I will note that the fact that that is at that price today has nothing to do with the two B of A reports you put before me.
Okay, and you would agree that that is a $9.25 increase above the September 9 price of $82.59? Just the math.
Well, not on that, I will even say that other than the 61 basis points of movement from September 9 to September 11, that the $9 and some change increase certainly did not result during the September 9 to September 11 period of the two B of A reports that noted the Dominion decision and clearly received pushback from the very investors who have driven up the price post September 11th.
And
Mr. Grantmeyer,
20,
Mr. Grantmeyer, we're going to take our afternoon break.
I have one more question.
Well,
and then I'm done.
let's do that.
And you would admit that the 925 increase comes out to 11.2%?
I'll accept your math.
I have no further questions.
All right, let's take our afternoon break now, and we will come back at 3:15.
Please turn off your videos.
John, are you on?
Yes, sir.
Hey, John. Jim Wells, just doing a video check.
Yep, audio and video sound good. You're good to go, sir.
Excellent. Thank you very much.
Sure.
Okay, Joanne, are we ready? Great. Screenwriter, you are concluded.
Sir, I am concluded.
Okay. I don't have anyone else on my list asking to reserve cross-examination, but for the record, let me ask if there are any other parties who have cross-examination for this witness. If not, Mr. Mehta, we're back to you on redirect.
Thank you, Commissioner Clodfelter. Just a very few questions. First off, Mr. Fetter, you referred to a analyst report by Steve Fleischman at Wolf. And Commissioner Clodfelter, I think that was one of the new potential redirect exhibits. It was redirect exhibit 76. And if we could have that one marked as Fetter Rebuttal DEP Redirect Examination Exhibit number 1, that would be great.
Be so marked.
Thank you, sir. Mr. Fetter, you also referred to and then held up to the screen a, you might want to try doing it again, just to make sure I got it straight what this is, but it looks like, yeah, it's the stock price from of Duke Energy from September 9th through September 11th.
Yes.
Commissioner Clodfelter, that document, Ms. Monica Smith will circulate through the mechanism that the commission has previously set up about circulating documents that kind of come in. And if we could call that one once it arrives and is able to be identified, then Fetter Rebuttal DEP Redirect Examination Exhibit number 2. That would be great.
It will be so marked.
And counsel, that had 2 pages where it noted the opens and closes for those 3 days.
Okay, and I think what she will be circulating has both pages. I hope so. If not, we will fix it later.
All right, it will be so designated.
Thank you, Commissioner Clodfelter. Mr. Fetter, the counsel for the public staff, Mr. Grantmeyer, was asking you questions concerning securitization and is that being credit positive, correct?
Yes, I served on the securitization team at Fitch, and it was a means of bringing in funds to support certain needs of a utility.
Okay, and in North Carolina, and particularly the securitization, storm securitization that Mr. Grantmeyer referred to, comes about as a result of legislation recently passed, maybe a year-ish ago, by our General Assembly. Are you aware of that?
Yes, securitization in any jurisdiction and under any set of statutes would require legislation to lock in the revenue flow, which comes in at a lower cost due to the legislative enactment of an appropriate securitization law.
So is it fair to say that securitization could, in some circumstances, actually be overused and would be in the event that too much legislation was passed allowing it to occur?
Well, I've found across the country it has not been overused because I have not seen any jurisdiction where a securitization law was not supported by the full spectrum of interested stakeholders, from utility to interveners to consumer side. I haven't seen any legislature stand up to dissent from any of those entities and pass a securitization law. It has been consensual in every instance across the country within the legislature.
Okay. Mr. Fetter, Mr. Grantmeyer was asking you questions concerning testimony that he referred to from Mr. Lucas about exceedances of groundwater standards in the past and the sort of past activities of the company. with respect to the cost recovery that it is currently seeking. Mr. Grantmeyer asked about the company's past imprudence. And my question to you, Mr. Fetter, is the standard that the public staff is putting forward with respect to those past activities not imprudence, but equitable sharing and culpability?
Yes, as we've discussed, I think in my last cross, and then today when he was raising imprudence, it was actually a standard of culpability that staff is pointing to rather than the 100-year history of prudent investment review.
Have you seen the public staff's late filed exhibit number 1 in the DEC case that relates to the culpability issue raised in that case?
Yes, I have.
Do you have any comment on it?
Yes, I reviewed it because I think I had said to Mr. Junis in the last case and to Commissioner McKissick that if the commission were to go in that direction, it has to be fully explained and vetted out. And in fact, Commissioner McKissick had said, had called for a brighter line than what it is today, where it appears to be subjective. And Commissioner Brown-Bland offered the same thoughts to Mr. Junis. There's objectivity, but there's also a lot of subjective. So I reviewed very closely this late filed exhibit, and the things that concern me is that rather than creating a standard that investors could look at and understand, this document says it would be fact and case specific that is not amenable to a bright line test. The very thing that Commissioner McKissick was calling for, staff has said it's not amenable to that. And then it goes on to say the direct testimony of Mr. Manus discusses in detail the reasons for the public staff's equitable sharing recommendation.
I would object to this. I don't remember asking any questions about the public staff late filed exhibit number 1, and that's in the Duke Energy Carolinas case.
Mr. Mehta, your response?
Well, Commissioner Clodfelter, I have litigated cases in this state for close to 40 years. There seems to be, at least on in the mind of some interveners in this case, a very narrow view of redirect. We all know that cross-examination in this state is wide open. Redirect is governed in some measure by the scope of the cross-examination. But that does not mean that the cross-examiner has to raise a particular question. The cross-examiner raises a subject. Mr. Grantmeyer raised the subject of past imprudence. Well, I am asking Mr. Fetter additional questions about that subject which Mr. Grantmeyer raised. If he didn't want to hear any redirect examination about that subject, he should not have asked the cross-examination question on that subject.
All right, I'm going to allow the question to continue. Mr. Mehta's understanding of the practice in the courts of North Carolina is correct. The topic was opened on cross-examination. I think Mr. Mehta is entitled to explore that topic on redirect. You may proceed.
Okay, should I continue, Commissioner?
If you can remember the pending question.
Yes, thank you. I have very little further to say. That late filed exhibit states the direct testimony of Mr. Manus discusses in detail the reasons for the public staff's equitable sharing recommendation that are not tied to culpability. And then it's the concluding sentence in that exhibit that I, as someone who briefs investors about regulatory policy, I would have a very hard time explaining this last sentence. Additionally, as noted in the testimony of public staff witness Manus, the public staff believes that even in the absence of culpability, some level of sharing of CCR costs would be appropriate and reasonable in this proceeding. So from start to finish, this document has said there's no bright line. It proceeds to say, based on a culpability standard, then it says it does not necessarily need to be tied to culpability. And then it says the sharing could occur, meaning there could be disallowances, even if there was no imprudence and even if there was no culpability identified. And so this would be a very difficult document for me to take to the financial community and explain what the policies will be in North Carolina going forward.
Commissioner Clodfelter, I have no further questions of this witness at this time.
Thank you. Let's see if we have questions from commissioners. Commissioner Brown-Bland,
I have no questions.
Commissioner Gray,
No questions at this time.
Chair Mitchell,
No questions.
Commissioner Duffley,
No questions.
Commissioner Hughes,
No questions.
Commissioner McKissick.
No questions at this time.
All right, and I likewise have no questions. So, gentlemen, we are at the point of being ready for motions relative to exhibits. Mr. Grantmeyer?
Yes, the public staff moves Feder, rebuttal, public staff, cross-examination exhibits 1 through 5 be admitted into evidence.
All right, you've heard the motion. Is there any objection? Hearing none, the motion is granted. Mr. Mehta?
Commissioner Clodfelter, DEP would move the introduction into evidence of Feder rebuttal DEP redirect examination exhibits numbers 1 and 2.
You have the motion. Is there any objection to the motion? Hearing none, the motion is allowed. All right, thank you.
And Commissioner Clodfelter, the last request I have is, I believe Mr. Feder maybe he's not subject to recall, at least I don't think so. So we would like to have him excused. If,
All right, any party objecting to that request? If not, Mr. Feder, thank you for being with us. You are excused.
Thank you very much.
Okay, Mr. Marzo, we're back to you, I believe.
Yes, sir, Commissioner Clodfelter. I call Ms. Marsha Williams and Mr. James Wells to the stand.
All right, there's Mr. Wells. I see Mr. Wells. I do not yet see Ms. Williams. Ah, there she is. I see them both. Okay, will each of you raise your right hand, please? Do you and each of you solemnly and sincerely affirm that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Right. All right, Mr. Marzo.
Thank you, Commissioner Clodfelter. I'll start with you, Mr. Wells. Would you please state your name and business address for the record?
It's Jim Wells, 526 South Church Street, Charlotte, North Carolina.
Okay, and by whom are you employed and in what capacity?
Duke Energy Business Services, and I'm the Vice President of EHS Programs and Environmental Sciences.
Thank you, Mr. Wells. And did you cause to be pre-filed in this docket rebuttal testimony consisting of 68 pages?
I did.
Do you have any changes or corrections to your pre-filed rebuttal testimony?
I do not.
If I were to ask you the same questions today, would your answers be the same?
They would.
Did you also cause for pre-filed Wells rebuttal exhibits 1 through 4 to your rebuttal testimony?
Yes, I did.
And do you have any changes or corrections to your pre-filed rebuttal exhibits?
I have no changes.
Mr. Wells, did you also prepare a summary of your testimony?
I did.
Commissioner Clodfelter, at this time, I would move that Mr. Wells' pre-filed rebuttals testimony be entered into the records given orally from the stand, and that Mr. Wells' rebuttal exhibits 1 through 4 to his rebuttal testimony be marked for identification.
Unless there's objection.
Okay.
Hearing none, it is so ordered.
Commissioner Clodfelter, I also ask that Mr. Wells' summary, which was provided to parties previously as required by the Commission's orders, also be entered into the record as given orally here today.
Without objection, so ordered.
Ms. Williams, would you please state your name and business address for the record?
Marsha Williams. My business address is 2029 Century Park East, Los Angeles, California, 90067.
And by whom are you employed in what capacity?
I'm employed by Nathan Advisors, which is an international consulting firm, and I'm Senior Vice President.
Thank you, Ms. Williams. And did you cause to be pre-filed in this docket rebuttal testimony consisting of 134 pages?
Yes, I did.
And did you also cause to be filed an errata sheet identifying certain corrections to that testimony?
Yes, I did.
And can you tell me what you corrected on your errata sheet?
Yes, I corrected several small typos, but then I also corrected on pages 66 and 67 a few sentences of testimony that was corrected in response to DEP's corrected filing on September 30th to the public staff's information request 101-1.
Thank you, Ms. Williams. And do the corrections in your errata sheet alter your opinions or conclusions in your testimony at all?
No, they do not.
Okay. And do you have any additional changes or corrections to your pre-filed testimony?
No, I don't. Thanks.
And with the errata sheet in place, if I asked you the same questions today, would your answers be the same?
Yes, they would.
Did you also cause to be pre-filed Williams Rebuttal Exhibit 1 and 2 to your rebuttal testimony? Do you have any changes or corrections to your pre-filed rebuttal exhibits?
No, I do not.
And did you also prepare a summary of your rebuttal testimony?
Yes.
Mr. Chairman, at this time I would move that Ms. Williams' pre-filed rebuttal testimony as corrected by her errata be entered into the record as given orally from the stand, and that Ms. Williams' rebuttal exhibits 1 and 2 to her rebuttal testimony be marked for identification.
You've heard the motion. Is there any objection? Hearing none, the motion is allowed.
I'd also ask Commissioner Clodfelter that Ms. Williams' summary, which was provided to all the parties and to the commission, be entered to the records if given orally today.
Without objection, it will be so ordered.
Commissioner Clodfelter, per the stipulation entered into between public staff, the Attorney General, and Sierra Club on September 28, 2020, I ask that the live rebuttal testimony of Jim Wells and Marsha Williams from docket E7 sub 1214, located at the following volumes, be entered into the record. Those volumes are volume 27, page 189, line 1 through page 314, line 5, transcript volume 28, page 11, line 9 through page 138, line 7, and transcript volume 29, page 15, line 5 through page 79, line 10, be entered into the record in this case.
All right, you've heard the motion. Is there any objection to the motion? Hearing no objection, motion is allowed.
I'd also ask that the cross-examination exhibits submitted during the live testimony be moved into the record. Those are identified as Public Staff Wells Williams Rebuttal Cross Exhibit numbers 1 through 6.
You've heard the motion. Any?
I've got one more. If you want me to do both of them, I got one more.
Go ahead. I thought you were at the end. Go ahead.
AGO Wells Williams Rebuttal Cross-Examination Exhibit 1 through 2 as well.
All right, you heard the motion from Mr. Marzo. Any objection? Hearing none, motion is allowed.
Commissioner Clodfelter, the witnesses are now available for cross-examination.
All right, cross-examination, Ms. Lure and Ms. Yost. Which of you is going first?
Yes, this is Nadia Lure, and Mr. Wells, my questions are for you this afternoon. I'm looking at page 33 of your testimony.
Okay, I'm there.
And on lines 4 through 8, you state that while the company may have been aware in the 1980s that unlined impoundments in general could potentially impact groundwater, there was no substantial evidence showing that there was significant impacts resulting from DE Progress's facilities. And Mr. Wells, there was no groundwater monitoring at Asheville, Cape Fear, Mayo, or HF Lee until the 2000s, correct?
Right, so I think if we're referring to this time frame, right, it would have been Sutton, Roxborough, Robinson, Weatherspoon. Those, I think, are the facilities where we would have initiated monitoring up through the 2000 time period, and that's when the rest of the facilities initiated groundwater monitoring. That's correct.
Okay, so your assertion that in the 1980s, there was no substantial evidence showing significant impacts resulting from DEP's facilities, that's not based on groundwater monitoring from all the facilities, isn't that right?
So I think with this, let me just make sure I'm looking at the correct line. You're in the 3 through 7?
Yes, through 8.
Okay. So at that time, we had done studies at Roxborough in 1978. So there was some groundwater monitoring that had been done. That was voluntary. And that was well above anything that was required or above what was being done with the industry as a whole. But it was at least a chance at one facility to begin evaluating what, if any, impact is being realized from this potential that is being discussed in some of those historical documents we've been citing. Following that, you see the Mayo study that relies on the ROC study. And then following that, you see monitoring going in Sutton, groundwater monitoring wells. And then additional groundwater monitoring wells going in the 80s, additional wells going in Sutton in 86, additional in the 88, 90 timeframe. So the sites are beginning to, there is some groundwater monitoring going on as early as 78, and then you slowly are seeing more facilities incorporating groundwater monitoring. In addition to that, there are other factors that are relevant to this. So one of the big concerns with groundwater monitoring as a whole, particularly in the early 80s and in this early time period, is the impact to surface water or to receptors. So there's also, in addition to just wells in the ground, there's also surface water monitoring going on. That's going on both for purposes of the NPDES monitoring, meaning the permit monitoring. That was, all the facilities were permitted under the Clean Water Act and monitoring was being done associated with that. But also surface water studies on that receiving water body. So that would have captured, if you were beginning to see some impacts to groundwater and to surface water, which is a lot of what the thinking was at the time, it would have captured that. So that looked at typically, it varied by facility as when it was implemented and what was studied, but often it included fishery studies, looking for impacts to the fishery. Water quality studies, looking for impacts upstream, downstream type samples for understanding if there's impacts to the river. So there are a number of factors that come into play. The other piece of that is sort of, even if it's not monitoring, geological considerations come into play. So things like, if there is a study that's relevant in a particular region, that can also be at least a data point that's informative to that type analysis. So if it's, as we are aware, the Allen study associated with the Piedmont and the conclusions in the Piedmont region, some of the facilities within that you cited to that didn't have the early monitoring, which were Weatherspoon, HF Lee, those are in that Piedmont. So that data point's still relevant, particularly in those early 80s, as that risk is trying to be analyzed.
Thank you. And I'd like to discuss the Roxborough study briefly. And do you know how many down gradient wells were tested for the Roxborough study?
I don't recall. I know it's cited in the Mayo study, but I don't know if you have that number.
Yeah, so the Mayo study discusses the Roxborough study, and it says there were 2 down gradient wells, and I'm happy to go there if you would like.
I think it was, if I recall, I think there was some up gradient monitoring, down gradient. I couldn't remember, but I think that sounds right. 2 or 3 wells, and then I think there was also some off-site monitoring beyond that of like a drinking water well or a personal residence or something to that effect. But I agree that's referenced in the Mayo study.
Okay, thank you.
And I will tell you, I mean, and again, late 70s time frame, that's what the wells were installed. If you look at the 2015 CCR rule, I mean, to the extent we're judging whether this, 40 plus years ago, someone had an adequate well network. The 2015 CCR rule minimum requirement is, I believe, 1 upgradient, 2 downgradient, or 1 upgradient, 3 downgradient. It's in that, but it's similar type setup as to what.
If I could just add one quick thing, the information in the 1988 report to Congress that EPA put out did look at groundwater monitoring at roughly somewhere between 75 and 100 facilities, most of which were unlined, and found from that analysis that there was only 5% where they were seeing exceedances of standards at that time. And most of those exceedances were quite limited in extent. So I do think that was a reasonable additional piece of information that Progress would have had available to it in the 1980s.
Thank you. And Mr. Wells, in 1978, when the testing was conducted at Roxborough, how long had the East Ash Pond at that site been in operation?
I don't recall. I would have to look at that study again. I think that is cited in the Mayo study as well, where the wells are discussed.
Okay.
And I just don't remember.
That's fine. I can direct you to Lucas Exhibit 4 if you have that with you. It might be a little small to read, but we can take a look at it.
Okay. Just give me just a minute.
Sure.
Okay, I do have Lucas 4.
Okay, great. So this is a spreadsheet showing when each ash basin began operation. And in the left-hand column, you can see Roxborough. And then in the 4th column next to that, you see East Ash Pond. And then I don't know if you're able on a printout to read the date next to the East Ash Pond. It might be fairly small.
It is small. Can you read it in your version?
Sure. So this says 1966 through 1986. So it began operation in 1966. Does that sound correct?
I think that looks right here, yeah.
Okay. So the testing began in 1978. The East Ash Pond would have been in operation for 12 years. Is that right?
Yeah.
I think that is correct. Yes.
Okay, thank you. And we can refer again to this exhibit. Do you know how long the West Ash Pond had been in operation? And I can read this for you again. The chart says that the West Ash Pond began operation in 1973.
Right. I believe that's correct. I am struggling with that.
Yeah, I apologize for that. It's
very small.
fairly small.
I think that's consistent with what I think it says.
Okay, so it would have been in operation approximately 5 years. Is that correct?
That is correct.
Okay, and let's see, on page 23 of your testimony, lines 10 through 13. Just let me know when you're there.
I'm there.
Okay. You state that the results of the Roxborough study reinforced that the naturally occurring clay soils in the region can give essentially complete protection against the trace elements that occur in ash pond sludge. And Mr. Wells, when you say clay soils, what percentage of the soil is clay?
I don't recall what it's referring, what the percentage of clay is.
Could the percentage of clay vary within one site, within the Roxborough site? Do you know?
I don't know that.
Let's move on and discuss the Mayo study.
Okay.
And if we need to refer to it, I don't know if you have the Mayo report in front of you. I've been referring to Hart Exhibit 24A. I think it's in the record in several places.
Okay. Let me see if I can get a copy of that. Hart 24A?
That's right.
Okay, I'm there.
Okay. All right. So are you aware that the report stated that 12 test holes at Mayo were finished as observation wells in order that periodic sampling of the groundwater could take place?
Can you point me to that page?
Yes. So if you refer to page 13, and that's based on the bottom of the pages, the paper copy.
All right. Okay, I am at page 13.
Okay, and it's that first full paragraph.
Yes, I see that.
Okay. And it also states there that this was to allow for the detection of trace elements in the groundwater if contamination should occur in the future. Is that correct?
It speaks to, I think it's referring to water level measurements and the ability to also sample for trace elements if that analysis is needed for trace elements.
And do you know if this periodic sampling took place once the ash pond was constructed?
I'm aware that at least additional sampling occurred for purposes of the water level measurements. I'm aware of that. For purposes of confirming flow direction, I think that the sampling was continued for the purposes of evaluating flow direction and confirming that the groundwater flow direction was consistent with what they anticipated post-construction. Meaning that it was, and I think what they confirmed was it was actually flowing back in toward the basin. That's what the results were showing.
Okay, and do you know if the testing was done to test for the trace elements?
I don't know. Subsequent to construction, the permit that was issued required additional sampling of the Crutchfield branch for the purposes of confirming the concern that is discussed in the EIS, and I actually it's ultimately evaluated in Mayo, is whether or not there's a potential for a risk to Crutchfield branch through groundwater, potentially moving under the dam and up into Crutchfield. So there was an analysis done per the Mayo report, which is a report that you have me looking at. It draws very strong conclusions that says that it wouldn't be anticipated because of the surrounding geology, that filtration that would occur for any water that went through there, that it wouldn't reach to the point that it could impact water quality in Crutchfield branch. So that was the discussion that was going on in the Mayo study. That was the conclusion. Once the Mayo study was submitted to the agency and a permit's issued, through the agency, additional monitoring was placed on Crutchfield branch to confirm that any potential groundwater wasn't being realized as an impact to water quality standards in Crutchfield. And that sampling was ongoing. That occurred as required under the permit since 1982. And I would add, no, there's never, I have no belief that there's been any exceedance of a water quality standard in Crutchfield Branch since that was initiated.
Okay, but you don't know if periodic sampling of the groundwater took place in those 12 observation wells after this report was issued?
What I've seen through my review of the records has been the water levels that have been monitored in those observation wells for purposes of confirming the groundwater flow.
Understood. And groundwater monitoring at Mayo began in the 2000s. Is that correct? Is that your understanding?
That is correct.
And if I could have you turn to page 6 of this report.
Okay, I'm there.
And if I could have you, well, I'll go ahead and read the language. So I'm looking at the first full paragraph, and I'm going to read the second sentence, which states, the water levels reflect late summer dry season and are at or very near their yearly lowest levels. Seasonal fluctuations are probably within the range of 5 to 15 feet in upland areas and 2 to 5 feet in the valleys. So Mr. Wells, this means that when testing was conducted to determine where the water table was, the water table would have been at its lowest or near its lowest levels of the year. Is that right?
I don't know. I mean, it could, it would, I'm sure it would vary by year.
With respect to this statement, the water levels reflect the late summer dry season and are at or very near the yearly lowest levels. That would mean that during other times of the year, the water table would have been higher and therefore closer to the sluice coal ash in the impoundments. Is that correct?
I don't know that.
Okay. And those are all my questions, Commissioner Clodfelter. I don't believe my colleague Ms. Yost has any questions for this panel.
Right, Ms. Yost, is that correct?
That's correct. Thank you.
Okay, thank you. Then we'll move to Ms. Townsend.
Thank you, Commissioner Clodfelter. Based on the amended joint stipulation and the questions posed to staff, the Attorney General would waive any cross-examination of this panel at this time.
All right, that takes us to the Sierra Club, Ms. Lee.
Yes, thank you, Commissioner Clodfelter, and good afternoon, Commissioners. Good afternoon, Mr. Wells. Good to see you again. I have just a few questions for you today. You've testified that when the basins were constructed, they were consistent with industry standards and governing law. Is that correct?
That is correct, yes.
And is it right that you based that opinion on a review of historical documents?
It's based on my review of historical documents and current knowledge of the status of the basins.
Understood. Thank you. And would those historical documents include the history of construction reports that were prepared on behalf of the company pursuant to the requirements of the 2015 federal CC? I'm sorry, I think you're on mute.
I have reviewed the history of construction documents at some level of detail as well. Correct.
Okay. And those are all posted on the company's CCR rule compliance and information website. Is that right?
That is correct.
Okay. Did you review, Mr. Wells, the underlying documents that are cited in those history of construction reports?
I have seen some of those, and I would have reviewed the documents on the whole generally.
Okay. And with respect to the construction at the Mayo site, was the ash basin there constructed in a stream valley area?
Based on my review of the document, and this is where I'm going to refer to the EIS, because I think that the environmental impact statement, it's important that there are some statements in there that I think are relevant. So I'd like to bring that into discussion. But the environmental impact statement is just for additional context. Of course, this was a document that was performed by the Corps of Engineers for the purposes of determining if it could issue a 404 permit, which is a Clean Water Act permit that would speak to the issue that I think you're referring to, is whether or not you can have fill in a water of the U.S. So you're asking, would that have been a lawful construction?
Oh, I guess, sorry, just to interrupt real quick. My question's a little different, not whether it's lawful or not, but just physically, is that what happened?
It is not, and I'll refer to the EIS again for the purposes, the basis of my view of this. Within the EIS, the Corps is evaluating the environmental impacts on the whole, whether that's air, water, health, and is charged as part of that EIS to evaluate the various alternatives available for the operation or even to build the plant, even a no action alternative, whether benefits versus burdens and environmental impacts. So they go through the analysis and issued their draft environmental impact statement. One of the issues in there was the potential risk to Crutchfield Branch, both as it was currently constructed and future operations. So that's a lot of what the discussion is about. And the EPA commented on the draft EIS, which is the letter and that I believe was part of the discussion that was had with Ms. Bednarczyk. The draft EIS, of course, the next step would be for the Corps to go back, resolve comments for all commenters, which they did elsewhere in the document. They speak to that. And with respect to the discussion on the Crutchfield Branch, where the ash basin was to be located, the Corps indicated that was not, the Corps had not determined that to be waters of the U.S. And elsewhere within the document, you can find that there had been some relocation of the stream within the area of where the basin was going in, and that was, I believe that was tied to the reasoning of the Corps indicating. So point is, I think your question is whether or not it's the ash basin was placed in Crutchfield, and what I was understanding through my review of that document is that had been rerouted for the purposes of supporting the ash basin construction.
Okay. Are you aware that the history of construction report states that, quote, it appears that the ash basin was constructed in a valley area with the natural contours in place, close quote?
I'm not specifically aware of that statement.
Do you disagree with that statement?
Excuse me?
Do you disagree with that statement?
What I was referring to is it indicates that well, reread the statement if you would, just so I'm clear.
Yeah, sure. It appears that the ash basin was constructed in a valley area with the natural contours in place.
What I understand, again, from my, I don't think that is answering the question you asked, though, and that is, was the basin built in Crutchfield? What I was referring to is the rerouting of the stream. If you read the document that I'm referring to, it discusses in essence, upland of the area where the stream would otherwise flow, that there was a diked area that redirected the stream. So,
okay.
You understand?
Yeah, I've got what you're saying. Thank you. We can move on from that. Mr. Wells, the company upgraded the fly ash handling system at the Mayo plant, including the development of an on-site landfill in 2009, correct?
So as part of so we make sure we understand what we mean by upgraded the fly ash. So as part of the construction of the Mayo, and this was tied in with the environmental impact statement as well, the EIS. The Mayo facility originally was constructed with the ability to operate dry fly ash, as well as wet sluice ash, full capacity ash. In the environmental impact statement, there was an analysis that was referred to, a cost benefit analysis, that indicated in order to operate dry fly at Mayo, it would be over 2 times the cost with respect to the sluicing. So where the plant ended up was the ability to operate and store fly ash dry or wet sluice it. And if they did it dry, then they would use it for purposes of the market if they were able to market. And then with time, that there ultimately was a monofill that was built at the site. And I believe it was in that time frame. It was 2010 or 11 that you referred to. And with that, then the dry fly ash could be landfilled as well. But if you look back at the early 80s, there was still a need, even when dry fly could be utilized, there was still a need to have a wastewater treatment in the form of the basin for purposes of handling the bottom ash, which there wasn't the capability to go dry bottom, as well as other traditional waste streams that are managed via the basin under the NPDES permit program.
Okay, for that monofill you mentioned, just given the lead time needed for permitting and engineering and design and construction, do you know when the decision would have been made to switch to the dry handling that was available at Mayo and to construct that monofill?
I don't recall the specific timing on that. I'm aware that it was tied to move to zero liquid discharge, moving into the ZLD, and I think all of that was part of the last case.
Okay.
Last rate case, 2017.
And in 2013, the company converted from wet to dry handling of bottom ash at Mayo. Is that right?
I don't remember the exact year.
Okay.
Time frame. I just don't know if it's 13. At some point in there, we converted to bottom.
Yeah, I'm looking at your rebuttal, page 53, but.
Okay. I can look to that for verification.
Sure.
Page 53.
Yeah, I think it's lines 1 through 7.
Yes,
it's on line 3 there.
I see it refers to 2013 for dry by bottom ash.
Okay.
Dry bottom.
So if the conversion was ready to go in 2013, do you know when that decision would have been made to convert to dry handling of bottom ash?
I don't know.
Okay, but it would have had to have been made before the passage of CAMA and the adoption of the CCR rule. Is that right?
In 2013, that is correct. That would precede all of the above.
Okay.
And again, I would point that the Mayo system was tied to the zero liquid discharge upgrade that the facility was implementing at the site.
Understood. Mr. Wells, do you know whether the company was able to recover the costs of converting to dry fly ash handling at the Roxborough site? I think that conversion was back in the 1980s.
I don't know. I wasn't involved with that. I don't know.
Okay. And
I would point out Roxborough, I think, is a good example of an issue that had developed. And so I had indicated that as part of the operations that I've seen through my historical review is that when issues did develop, the company took action when there was a strong basis to move and manage things differently to manage that risk. And I think Roxborough was an example of that. And so there was based on what they were seeing in Hyco Lake, company had discovered fishery impacts there and a need to make some adjustments based on the potential selenium impacts as the cause, which it actually ultimately was believed that was the cause, and that converted. That served as a strong basis to adjust the operations there to manage that risk to the ecosystem.
if there had been more robust monitoring of the groundwater around that basin, might those impacts to the fisheries have been avoided?
No, the issue was impacts to surface water, and it wasn't impacts to surface water from groundwater. That was not the cause. It was a direct discharge into
Understood.
via the pipe. The permitted, we were permitted to discharge X amount of selenium concentration, right, under the state permitting rules. And over time, you can see, and this is what we learned and have adjusted to, and been in a position that we've been able to manage this more effectively. But back then, 80s, we didn't realize until it was revealed through the fishery studies that the selenium could cycle up, bioaccumulate within the fisheries. And
Understood.
doing so, and it takes some time before you see that. But once we saw it, then we made the adjustments at the facilities where that was a risk point for us.
Okay. Mr. Wells, just switching gears a little bit, were you able to watch the cross-examination of your colleague, Ms. Benarsik, during this hearing?
I was observing most of it. I didn't see everything.
Okay. I believe a number of questions about groundwater that were posed to Ms. Benarsik, she indicated that you might be better suited to answer those. Do you recall that?
I do.
Okay. And so I'll ask this again specifically of you, Mr. Wells. Has an exceedance of a 2L standard ever been recorded beyond the compliance boundary at Mayo? And just to make sure I'm clear, I'm not asking if there's been a violation of the rules. I'm asking if there's any coal ash constituent and a concentration that is above the 2L standard has ever been recorded beyond a compliance boundary at Mayo.
Well, there's been a great deal of monitoring outside the compliance boundary at Mayo, and there is a data set that we've produced that reflects all of that. Of course, we're continuing to do that monitoring today. There have been detections outside the compliance boundary that would be above the published number in the 2L rule. So for instance, iron, pH, manganese, they've been detected. So now let's follow that line of thinking. So now you've got pH that's above the published standard. And then you have to ask the next question. What is background? That's the first question. So then you have to, where you have naturally, under the 2L rule, where you have naturally occurring constituents, which is all of the above. Then DEQ establishes the background. And if you're above, if that's above that published number, then the legal standard is the background. So with respect to iron and manganese and pH, that's where you're at. So now you would have to ask, are you above background outside the compliance boundary? Then if you look at the pH hit, because we got pH outside of the range and it was low, meaning it was below the band. It's got a band of, I don't remember the number, but let's say it's between 6 and 9, it would have been below 6. Very common to see that naturally, 1, but 2, we also there, and this is, I would say first, this is a very good example of why you can't take a single well result and cherry pick it and make broad conclusions from it. And this is why, with respect to groundwater monitoring, it's important to look at the network as a whole and the data as a whole. So for the pH, what was determined is we had a grout impact inside that well post-construction and following development of the well. So the pH was spiking, and then it ultimately curved. And then once the well stabilized, pH fell back within the background range for the site. With respect to iron, we had an iron background number early on that was later adjusted, and manganese the same. So the iron and manganese numbers, all the numbers we've seen to date are below what has been the latest determination of background by DEQ for those 2 parameters. We also, at the site, had strontium that we had seen. I think there was an antimony that we had seen. So with respect to those 2, again, you got to look at those and say, what is this? And both of those were determined to be within the range of normal background, and the state has since removed those from the constituent of interest list for those wells going forward for purposes of developing or evaluating corrective action.
Okay. How about boron or cobalt or vanadium?
So boron has never been above standard outside the compliance boundary at Mayo. The vanadium, I don't remember specifically. Cobalt, if I remember, that one ultimately fell under the approved background with respect to cobalt. But I can tell you, there's not at this point an indication to us that there's an exceedance above background outside the compliance boundary, above what would be the 2L standard, which in most of those instances would be the background number established by DEQ for those parameters.
Okay. And at the Mayo site, there are tow drains at the dam. Is that right?
That is correct. They were installed at the time of construction.
Okay. And did the company ever redirect outflows from those tow drains?
Yes.
Okay. And at what point in the history of the dam? Is that a sort of an ongoing set of actions taken?
So the tow drains at Mayo, this is consistent with kind of what we've talked about before. These are obviously built into the dam. They're part of the engineering. They were designed to relieve any water pressure that might build up in the dam to ensure dam safety. And these were obviously part of the regulatory requirement as far as how we monitor for dam safety. We would have monitored these tow drains for make sure they're operating properly, and those reports were provided to the state and other regulatory bodies. And then this was consistent with what I've referred to, and I've referred to it in the DEC case. There was a good bit of testimony, the Duke Energy Carolinas case, regarding seeps and tow drains, and this is in that category where in 2010, under the Hanlon memo from EPA, there was reference to the states to begin evaluating permitting or whether these tow drains and seeps should be captured under a permitting scheme, or whether or not to evaluate whether or not what's the regulatory treatment of these, what's the proper treatment for these. And that's when the company in Progress did, similar to I've testified with respect to Duke Energy Carolinas, Progress had approached the state about permitting these types of, at all of its facilities. And that was, of course, DEQ had indicated, as I indicated in my prior testimony, and in the 17 case, what I referred to there is that the states had indicated it was a low priority, it was de minimis. So they were not moving forward with permitting those. And then beginning in 2014, we did an even broader outlook to have all of those seeps and tow drains permitted in that time frame. And of course, now we've got resolution through SOCs and permits, but in that window between that era where we were trying to get them permitted and DEQ wasn't moving forward with the permits, we did take action where feasible to collect some of these tow drains, and in most instances we'd pump them back to the basin until we could get some sort of clarity on their regulatory status and the need to either permit them or other action. And that action was implemented at Mayo.
Okay. Mr. Wells, earlier in your testimony, you mentioned a 2015 settlement between the company and DEQ regarding the coal ash site. Is that correct?
Can you restate?
Do you recall? Sure. I'll restate that. Do you recall mentioning a 2015 settlement between the company and DEQ? I think you referred to it as the Sutton settlement.
Oh, yes, I am familiar with the Sutton.
Okay. And just to make sure we're talking about the same thing, that settlement was finalized initially on September 29th, 2015, with the entry of an order of dismissal by the Office of Administrative Hearings. Is that right?
I do see that the document is signed on, I think you said September 29th, 2015.
Right.
Yes.
Okay.
Wasn't familiar about the order of dismissal, but that makes sense.
Sure. Okay. Are you aware that on February 23rd, 2016, the company sought to amend that order of dismissal to exclude the language that referred to the settlement of claims at any site other than Sutton, and that the administrative law judge issued the amended order to do just that?
Can you restate again? I'm sorry.
Sure. Are you aware that on February 23rd, 2016, so a few months later, the company came back before the ALJ and sought to amend the order of dismissal that had accepted the settlement? And they sought to amend that order in a way that would exclude language referring to the settlement of claims other than the claims that specifically related to the Sutton site.
I recall a follow-up. That's about it. I would have to look at the document.
Okay. Those are all my questions. Thank you so much for your time, Mr. Wells.
Okay. Thank you.
All right. Is there any other party desiring cross-examination for this panel? If not, Mr. Marso, we're back to you on redirect.
Thank you, Commissioner Clodfelter. Just have a few questions. Starting off backwards with Ms. Lee's line across. There was a discussion a moment ago between Ms. Lee and Mr. Wells regarding the environmental impact statement for Mayo, raised several times yesterday as well. And there were some comments made yesterday regarding EPA's view of the project within the EIS. And I was going to ask Ms. Williams, were you aware of that?
Yes, I did review that material.
Okay. And so you're familiar with that document as well?
Yes.
Okay. And briefly for me, you have, as a former EPA regulator, could you tell me your thoughts and comments on the position that was taken yesterday regarding EPA's position on the document?
Well, I think what's important is this is a 500-page document, and the discussions that were occurring when Ms. Bednarsik was on the stand had to do with comments that EPA had provided to a draft environmental impact statement. And if you go through the final environmental impact statement, the issues that were raised by EPA were addressed in the final environmental impact statement. And one of the key aspects about the final statement is that it said the final EIS had looked at all of the issues that had been raised with regard to groundwater and the ability of groundwater potentially to impact Crutchfield Branch. And the solution to that, which was laid out in the final EIS, was that it would be addressed through the NPDES permit, the Clean Water Act permit that addressed Section 402 of the Clean Water Act. And in fact, that's what happened. So one of those conditions was, in fact, the question of the need for a groundwater study, which was the study that Mr. Wells talked about this morning, performed by Mr. Floyd. But other aspects of that dealt directly with the question of what were the appropriate standards for the NPDES permit with regard to the effluent guideline standards. And EPA had raised some comments in their draft comment, in their response to the draft, about the status of the effluent guideline standards. But in fact, the effluent guideline standards were developed by headquarters, not by EPA Region 4. And EPA headquarters had not finalized its standards for dry fly ash handling until 1982. So effectively, what the final EIS said is, we will look to the NPDES permit to address all concerns, and we believe they are addressed. And then the 1982 permit put into the permit both the requirement to construct the pond according to the recommendations in the Floyd study, which included using clay and bentonite in the areas of the pond where there were rock outcroppings or stream channels. And I think Mr. Wells covered that in his rebuttal, demonstrating that that had been done. And it did require monitoring in Crutchfield Branch. in the permit as suggested in the final EIS. So I think EPA's comments were actively resolved and considered in the North Carolina NPDES permit. And I would point out that EPA does have authority that if they felt that that NPDES permit, which was issued by the state, was not protective, they could have required additional provisions in the NPDES permit. But it appears there was no need for that because the provisions in the permit were deemed protective both by the state of North Carolina and by EPA.
Thank you, Ms. Williams. And you mentioned the NPDES permit for Mayo. Do you have potential redirect Exhibit 79 with you? And that is
I think I can find it. Let me see.
Commissioner Clawfelter, this is the 1982 Mayo NPDES permit filed as a potential redirect exhibit this morning.
I believe I have a copy of it. It's not marked as that exhibit, but I have a copy of the permit.
And for the record, I would ask that that NPDES permit be marked as Williams Wells Redirect Exhibit 1.
It will be so marked.
Yeah, thank you. What does this permit tell us about how the issues raised by EPA were resolved at Mayo? Ms. Williams.
If you go to the next to the last page of the permit, I think it's on my version, it's page 18 of 19. There's a section Roman numeral I, and that section discusses the way in which the permit resolves the issues, which is that there shall be no direct discharge of wastewater from the ash pond to Crutchfield Branch. And then it talks about the need for the study and incorporating the results of that study. So unless you want me to read it into the record, it is addressed in section I in the permit. And that picks up all the requirements that were actually discussed in the final EIS in I think section 2.2.2 of the final EIS.
Now, Ms. Williams, there was a characterization of EPA's comments on the draft EIS as the state of knowledge broadly as to ash handling. Do you agree with that characterization?
No, I don't agree with it as that was stated for two reasons. One, I think Mr. Wells actually referred to the fact that the EIS itself provided specific cost information at the Mayo plant with regard to dry ash handling, dry fly ash handling. And that is inconsistent with some of the comments that EPA had made generally based on its national look at that time. Obviously, EPA continued to review this and finalize that requirement in 1982. But secondly, and I think really importantly, the EPA Office of Solid Waste continued to look at this whole issue of whether or not unlined ponds were protective throughout the 1980s, as I had mentioned earlier today, and also looked at the question of groundwater monitoring and continued to find both unlined ash ponds and the need for groundwater monitoring to be site specific, and did not find them to be, and found them to be the industry standard and not unreasonable with respect to impacts on groundwater through the 1980s. And you can even take it beyond that because EPA did not really make this determination until it finalized the CCR rule in 2015.
Thank you, Ms. Williams. Similarly, earlier this week, witness Quarles talked about groundwater monitoring and ash ponds, industry standards, and what the EPA knew in the 1980s timeframe. Were you right here when you testified? Were you listening to that?
Yes, I was.
Do you have any comments about his testimony as to those issues similar to what you've just talked about now?
Yes, I was really somewhat disturbed by his comments. I was at EPA throughout this whole time frame. I started in 1970. I left in 1988. He expressed his opinions that he disagreed with what I had to say about the state of groundwater monitoring. He also stated that
Objection. Commissioner Clodfelter. Ms. Williams' opinion on the testimony of Mr. Quarles is not.
I'm sorry.
You're getting terrible feedback. We're getting terrible feedback.
Is that better?
It's better.
Okay. Ms. Williams' opinion on the testimony of Mr. Quarles is not appropriate for redirect.
Commissioner Claude, oh, I'm sorry, Commissioner, go ahead.
Go ahead, Mr. Marzo.
Commissioner Claude Felter, one, I tied that opinion exactly to what was asked during the cross, but I also would let the commissioner know, as I know he's well aware, that earlier this week and part of last week, I think with Mr. Robinson, not this week, but last week, Mr. Robinson, there was a discussion about allowing a broader redirect should issues that we believe should have been raised during cross were not raised. This is in line with that. I only have a few more issues. Commissioner Claude Felter promised to be efficient on that.
Mr. Marzo, I'm going to allow you to continue because you are indeed correct. We had a conversation about that last week, and there was an understanding that redirect would be a little bit broader so that there wasn't areas that were left unexplored through the cross-examination. I'm going to allow you to continue. Let me check in with you, though, given the time. I do not know how many questions my colleagues may have for this panel. So let's put that to one side because I can't predict that. But if we were to push on to 5 o'clock, do you think we might be able to wrap up today, or do we need to come back tomorrow?
I may be able to get done, Commissioner Claude Felter, but I can't make a promise to that.
All right, let's try to go till 5. I've got our court reporter with us till 5. She can stay a little later, and we know Ms. Williams is on the West Coast, and that means a late start in the morning. So if we can't get done by 5, we'll push on till 5 and see where we are at that point. Okay.
Yes, sir, and I will try my best to be as really efficient in that.
Please continue. So, please continue.
Ms. Williams, if you would continue your response.
Okay, I think what I was saying is that he also expressed the opinion strongly about the state of groundwater monitoring and whether that monitoring was required by EPA. He didn't cite references in his response, nor were there supporting references in his testimony on that. And I would just say, again, I lived this for a very long time at EPA. And I will tell you that groundwater monitoring was very different in terms of the knowledge level in the 1980s than what it is today. And that included things like the definition of what a perched aquifer was that was defined as part of the uppermost aquifer. But it also included whether or not groundwater monitoring on a site-specific basis was deemed to be high priority and appropriate, and it was specifically deferred to the state to make those determinations. So I would just say, if you want to compare both to what EPA knew and to what industry practices were, I'm not going to repeat all the statistics that I put on the record in the DEC case, but unlined ponds were the most prevalent and common type of pond. It was in use throughout the 1980s, well into the 2000s at the time of the CCR final rule, and that DEP was ahead of the curve in terms of industry standards of starting its groundwater monitoring before it was required, before the majority of the industry had it at all sites. And DEP did begin undertaking coordination with DEQ to react to the results of the groundwater monitoring. I think they were a leader in this particular situation.
Thank you, Ms. Williams. Is there still an echo? Can you hear me? Clear, okay. Ms. Williams and Mr. Wells, did you hear the testimony of Doss panel's Raleigh panel earlier this week on Friday? Last week, I'm sorry, I keep thinking this week, but last week on Friday?
I think I heard most of it.
Okay, and I'm just going to ask you 1 or 2 questions about this, but Ms. Forrest had introduced AGO Cross Exhibit 1, which is a 2004 decommissioning handbook for coal-fired power plants. to Mr. Doss and asked him to read a particular sentence in that document. At that point in time, I conferred with her and told her that this panel would be a panel that could give more context to that paper. Can you provide your understanding of that report and its purpose?
Well, if I start, that report was definitely focused on full facility decommissioning. And it did look at ash pond closure as one item in decommissioning. What I do think is important is to trace sort of the knowledge as to what was appropriate with regard to ash pond decommissioning. The report to Congress did discuss, the 88 report to Congress, EPA discussed that, and I think I generally referenced it, but it is Exhibit 4-2 of the EPA report to Congress. But I also think it's important that in 2001, there was an explicit report put out by EPRI on ash pond closure. And that report focused on the importance of dewatering of the basin. And really it was dewatering of the basin as opposed to any other aspect, including caps of it, that would be the most important in terms of appropriate closure of the basin for protectiveness reasons. So I'm sure Mr. Wells might want to supplement, but that's a few comments I would have.
I think the only thing I'd agree with that. The only thing I'd add, one of the sites that was studied there was the Arkwright facility, and I'd looked at that just to understand a little bit more, and it was also tied a little bit to one of the questions that have been asked of me with respect to, I think Arkwright, one of the focuses of the 2004 report is that this is kind of beginning of some decommissioning of coal facilities. So it's referencing several different facilities, but the Arkwright facility in particular, they'd moved toward a closure. And I've done some follow-up to understand what they, under the current standards, whether that closure was adequate. I understand that is that has now being, although it had been closed under the prior rule, under the state rule, under the current rule, it's being reworked, and that ash is being excavated and put into a smaller footprint and closed in a different manner. So there's additional. At first, initial closure wasn't adequate to meet today's standards, so it's being reworked. Is what I noted.
And was that closed in accordance with at the time in accordance with the state rules? Is that your understanding?
That is my understanding. That I think I believe it was Georgia. The state had its rules there. They had clarity on they had a requirement with respect to what the closure requirements were, and so the initial closure was pursuant to the state rules, and then the follow-up closure was pursuant to the state CCR rule.
Okay, and when we talk about closure, just one last set of questions on this. We talk about closure and what was understood and expected during the time. Are you both, I believe Ms. Williams, Mr. Wells, you both are familiar with the 1988 EPA report to Congress?
Yes.
Okay.
Yes.
Now, there's a diagram that's been talked about in this case in that report, and I believe it's referred to as diagram 4.3. Are you familiar with that?
I think it's Exhibit 4-2.
4-2, that's right. And do you have that, Ms. Williams?
I don't have it in front of me, but I can get it. It's out of the joint exhibits, I believe.
That's right. In fact, it is joint exhibit 13.
I have it.
Now, before we go to the actual exhibit, could you turn to page 411 of that report?
Yes.
And would you mind, to give context to the discussion we're about to have, could you read the paragraph starting at the bottom with the word historically, and just read up to the 45%, last sentence, like a sentence and a half.
It says, historically, wet ponding has been one of the most widely used disposal methods for coal ash and FGD waste because it is simple and easily implemented. In 1983, about 80% of the waste management facilities used by utilities employed some type of sedimentation treatment pond. Most of these treatment ponds were used directly as final disposal impoundments. Parentheses, about 45% of all facilities. See section 4.2.1.2.
Now, if you look at the diagram, which is, as you point out, Exhibit 4.2, can you describe for me what that depicts?
It just shows essentially the typical stages in the life of a pond. So it starts out with a pond that's active, and then a closed storage pond with the waste removed, which is one scenario. And then the last picture is a closed disposal pond with waste remaining in it. And it just shows that essentially you end up with soil over the filled solids and then some type of vegetation that ends up growing.
And that was a widely accepted approach?
That was the standard, or pretty much the standard approach at that time.
And Mr. Wells, maybe one final question to you. Is your perspective that Duke Energy Progress was adherent to standards throughout the time that it was operating salt coal ash ponds in regards to closure and treatment of those ponds over time?
Yes.
Okay. Commissioner Clodfelter, I think I'm able to trim it down to those questions.
Okay, thank you, Mr. Marzo. Let's see if we have questions from commissioners. Commissioner Brown-Bland.
Yes, for Ms. Williams, in your opinion, would DEP have been prudent to wait until 1992 to perform groundwater monitoring at its CCR basins? And I asked 1992 because you've testified in the previous proceeding that it was 1992 before EPA had groundwater monitoring standards, clear ones.
I think what I said previously, Commissioner, was that it was 1992 when EPA issued its most expansive guidance document about how to go about doing groundwater monitoring. Its focus was really hazardous waste facilities, not ash ponds, but it had much applicable information in it. So, but the answer to your question is yes, it would have been prudent to wait, absent either a decision by DEQ that it was necessary to put groundwater monitoring in prior to that time frame, or absent any information that came to light about a specific situation at one of the Duke facilities. I think, as Mr. Wells pointed out, and I believe I have in my testimony as well, there was groundwater monitoring at 4 of the sites, DEP sites, by 1995, I think, and the remainder went in post-2000, but all of it went in before it was required to go in either by North Carolina or by EPA.
So, in your opinion, waiting to 1992 would have been prudent?
On a case-by-case basis, yes.
All right. And I think you also testified that EPA had attempted to define the perch zone from 1978 to 1986, and that they ended up advising the utility to, quote, work with your agency on the issue, end quote. Was there no definition of perch water or perch zone prior to 78?
There's a definition, but it's a very general definition. In 1978, there was a definition that talked about a particular volume of water that would have to be able to be come out of a perch zone for it to be part of an uppermost aquifer. And that got rescinded. That did not stay in effect. And EPA put a definition in that basically said there needs to be sufficient water in order sufficient water, and then, but it couldn't define any number. So again, it was in that context that they said that you should work with your regulatory agency on whether any particular perch zone would qualify. And I think particularly we spent a lot of time talking about this in light of the Allen facility, and I realize that's DEC. But the reason that I think that's important is if you look at the report that was being cited with regard to Allen, it was quite clear that they couldn't get water out of that perch zone. And it's why they went below that perch zone in order to get a monitoring well where they could get water. And EPA certainly looked at the Allen data in detail when the AD Little report was completed and felt that it had been done appropriately. So I think it's very hard to sit here today and try and determine that there was something improper about the selection of the uppermost aquifer in the particular case of the Allen facility.
If I could add to that.
Yes.
Just, I mean, because I had looked at that as well, and it seemed the perched water discussion was getting a lot of more weight than I was when I was evaluating when was perched water being referenced in the prior reports. There were really two reports that were relevant during that discussion. It was the AD Little study as well as the internal Allen study. And between those two reports, there were 25 wells installed. The reference to perched water only occurred in 5 out of the 25. 2 of those 5 were background wells. So they're up gradient of the basin. So this, and there seems to be an implied, we should have put it deeper to be closer, but anyway, 2 of those were background wells. The other 3, the first out of those 3, the first time it's referenced, it does have in it the parenthesis that specifically calls out that it went below that perch zone for the purposes of ensuring adequate sample volume. So point is that you put in a well that if you can't pull a sample out of it, it's not adding any value. The other thing I'd mention is there are times, I mean, even today, when it could be perfectly, you should install into the aquifer for purposes of getting an adequate sample to ensure you're getting results reflective of what the question you're asking. So for instance, here, if you're doing a down gradient sample to understand if potential contaminants are migrating beyond the basin, then it's possible, and again, it's all site specific, but it's possible if you put that well in at a perch zone, which isn't seeing that lateral aquifer flow necessarily, then you may miss exactly what you're sampling for. And I say that only because I'm not asking, with respect to those studies, they are what they are, but we're doing a 35-year plus year look back on that expertise. And I think I just think it's very, very difficult to do this accurately. And some of the things I've heard in the prior testimony to me are just not fully technically accurate in all instances, or at least accurately representation of the issue as a whole.
So, Mr. Wells, in your opinion, back in 1978, would a reasonably competent engineer or hydrologist been capable of designing an effective groundwater monitoring system for a CCR basin?
Well, I think they did that at those basins where they did it. They did what was consistent with their understanding and the science that had developed to that point and the groundwater that they put in. And I believe it was consistent with the technical standards at the time. And it was relied on by a lot of folks who had the expertise to do it. So they were the experts at the time.
And Ms. Williams, that same question, a reasonably competent engineer or hydrologist would have been capable of designing an effective groundwater monitoring system for CCR basin?
Well, I guess the way I would answer it is they did the best they could to put in a system based on the knowledge of the time. If you're going to do 20/20 hindsight and look back at that, you probably will be able to conclude that that wasn't, certainly by more recent standards, an acceptable or a good system, but it was if you evaluate it against what was known at the time. And I think in particular, it really was believed at that time that a relatively limited number of wells, groundwater wells, could help you understand the system. And it was not until many decades later, really, that we understand that it takes a very large number of wells to truly understand the complexity of what's going on in the subsurface adequately. And that, so you have to evaluate the 1978 system with what was done at the time. And against that system, I agree with Mr. Wells. It would have been considered adequate.
And so back on the perched water or perched zone, in your opinion, would it have been prudent for DEP to wait to perform groundwater monitoring at its CCR basins until some date after DEQ had defined perch water or perch zone?
No, I don't think that, I'm not saying that. What I'm saying is that if it was determined that there was an important reason based on site-specific characteristics to put a well system in, you would have done the best job you could to put a well system in. Whether that would have been a particularly effective well system is a different issue. But if based on site-specific parameters, it seemed important, you would have put one in, like was done at Sutton. But it may not be fully adequate by what you might know 10 years or 20 years later.
And same question I asked with respect to DEC, based on your knowledge and professional judgment, on what date did DEP become, did it become reasonably known that it would be prudent for DEP to dispose of CCR by some means other than an unlined basin?
Well, I think the way, Commissioner, that I would answer your question is DEP clearly determined by 2006, 7, 8 that it wanted to do groundwater monitoring at all its facilities so it could answer that question. And so it put well systems in, initial well systems in at all of the DEP facilities. So 4 had already had the systems in, the rest of them put the systems in. And so in order to answer that question, you have to begin to collect data. And that's what happened starting in 2009. And as a result of collecting data, additional wells had to be placed in, both up gradient, down gradient, sometimes cross gradient. And so DEP was in that process starting in 2009, 10, working with DEQ. And that's what was going on aggressively in this whole window of time prior to the time that EPA issued the CCR rule and specified that this was required. So DEP had its systems, was improving its systems, was developing sophisticated fate and transport models to predict what was going on. And that was pretty much what you had to do before you could answer the question of whether it was necessary to move to either an active corrective action scenario or to close the ponds to be protective.
All right, thank you. Mr. Wells, what were the facts that led DEP to decide in 1986 to install a clay liner at the basin, CCR basin at Sutton?
So that was actually 1984, I believe. The 84 basin at Sutton did receive a clay liner. The facts there surrounded an elevated chloride. It actually originated from an elevated chloride that was being detected at the adjacent facility, which was the Hercafina site. And I don't know if it was actually detected at Hercafina, but certainly in the vicinity of that facility, there was concerns of chloride impacts to Hercafina. Hercafina was an industrial facility. It had large pumping wells. I don't remember what their practice was. It was something that required large extraction wells. So they were pulling groundwater fairly aggressively from the Sutton site, and they were receiving some chloride. There was some concern of chloride impacts there. The ultimately, the source was believed to be the cooling pond, not the ash pond. There was already an ash pond there, not the new 84 ash pond. It was the historical ash pond. But the cooling pond at that time had its intake in the Cape Fear River that had a very large tidal influence. In fact, if you speak to the folks historically, Sutton Cooling Lake had at times they saw a saltwater type influence in terms of the fishery. They would see fish that were representative of that as well. So this chloride impact was from the Sutton Cooling Pond, not the ash pond. That was an important point. And that was largely because of the salt water where the intake was in the Cape Fear in time. And as the company began to work through that, they were looking at putting in a new basin. 84 basin was permitted unlined by DEQ at the time, but in discussions, as I understand it, discussions between the company and Hercafina, they wanted to address that risk, and they recognized that in the future, that would be a risk mitigation, was to ensure the new basin lining it would mitigate any potential risk of that being a contributing factor to any concerns for that neighbor. So the company installed a line facility. That also ultimately, I mean, just to finish the story, that ultimately the company moved that intake off of the Cape Fear, or actually moved it several miles upstream of Cape Fear. So we had fresher water then feeding the Sutton Cooling Pond. And then that chloride issue in time did in fact dissipate.
So at the time it was decided to go with the clay liner, was there an assessment by the company of using a synthetic liner?
I don't know that whether that was evaluated or not. I do know at the time, and I think Ms. Williams can speak better to this, just given her knowledge at the time, direct knowledge at the time, but certainly clay liners at the time, I think, were evolving, and clay liners certainly were at that point.
But you don't know about the synthetic liner.
I don't know that there was an analysis or I don't know, Ms. Williams may be able to speak to the how prevalent the synthetic liners were in that pond would have been designed and constructed.
Yeah,
Well,
they were.
I was just looking as to whether DEP did anything with a synthetic liner. Go ahead, Ms. Williams.
Sorry, I was just going to say they were not particularly prevalent in that time frame at any, not only coal ash ponds, they weren't prevalent in any industrial surface impoundments. And I think EPA in March of 2020, in a Federal Register notice, I noted this because EPA said even where they looked at the ponds that were lined today, 2020, very few had composite synthetic. Again, there's a synthetic liner and then there's a composite liner. And EPA feels the composite liner, which is a combination of clay and a synthetic liner, is the most protective. But very few ponds, including new ponds, have been built with composite liners. So I think, I don't know whether, I haven't seen anything to go to the issue of whether DEP considered putting in a synthetic liner, but I can tell you that EPA was still doing a tremendous amount of research in our Office of Research and Development in the early 1980s as to the best kinds of liners, synthetic liners, that could be used with different types of waste streams, because you have a couple of problems with synthetic liners. One problem you have is just installation issues. And if you get a tear or something as you're trying to put in a massive synthetic liner. But the second issue you had was whether or not there would be interactions between the waste and the liner material. So a lot of research was still going on that in the early 1980s.
All right, Mr. Wells, based on your knowledge and professional judgment, on what date did it become reasonable that it would be prudent for you to dispose of CCRs by some means other than an unlined basis, specific to DEP?
Specific to DEP, I would agree with Ms. Williams and her discussion on that point.
And so what is your judgment, what knowledge is your judgment based on that time frame?
I would base it on what the company was seeing if we evaluate over time, and they weren't seeing these risks, and where they did see a potential impact, they were dealing with that specific risk and addressing it in a positive way. So over history, appropriate actions were taken. And then, groundwater is you see, along, again, that you see some actions being taken with groundwater monitoring going in, early studies in the 70s, groundwater monitoring going in the 80s, additional wells going in. It's based on what we're seeing, development of additional groundwater monitoring in the 90s, all sites monitored in the 2000s. And because there is no risk being realized through that groundwater impact that it otherwise being managed separately. Those items, then there's nothing suggesting an action of that nature. Now you get up into the 2000s, the company's getting more aggressive with the groundwater monitoring. They're beginning to evaluate their results with the state up into 2010 to 2013 timeframe. 2015, the rule actually comes out that begins to get more prescriptive as to what you see, what drives closure, and the same with CAMA. So I think you're in that, you know, you're all.
So in terms of the data collection, are you saying 2009 or after? Or
No, I'm saying the data collection is the beginning of an analysis of what is going on, you know, and additional wells are going in. So you, again, remember groundwater is detection, assessment, corrective action that's the traditional approach. So you're in that detection mode early. Then you move toward assessment. And that means you do more wells. You begin to really understand the horizontal and vertical extent of the impacted area. And then based on all that, you're using all that to inform what might be the right next steps with respect to closure or toward managing the source. So all of that data is what's going on in that time frame. The data, and so you're, you know, based on where we're at today, we're still evaluating that corrective action, although CAMA and CCR have now driven the closures. And
Mr. Wells, can you help me delineate in your testimony how much or what part of your testimony is based on your review of historical documents versus your direct personal knowledge?
So I started with the company in 2009.
So for anything before, your knowledge and testimony is based on historical
review of documents. And I mean, I don't want to cut that short. That means I've reviewed, for instance, our monitoring database, our well network, our permit compliance, our permit requirements, past permits. I've reviewed all the historical documents that have been cited to in this record. I've reviewed all the exhibits that have been cited to in this record. And I've looked at, you know, even more than that. I've also had discussions with various people to ensure I've got accurate information represented for the issue. What I've found through this is that there are multiple issues, multiple sites, multiple years, a lot of detail that goes around a lot of these things. For instance, just the issues you've asked me here. Each of those is very detailed in terms of what would have been personal knowledge on those issues. So I do believe I'm the best witness to speak to all this, having done the level of research that I did to compile all that together.
Mr. Wells, could you provide a late file exhibit?
Commissioner Brown-Bland, we're going to need to break so we can let our court reporter go. We are not going to finish today. And I need to do, if you'll hold your question and we'll resume with you in the morning. Mr. McCoy. Mr. McCoy, are you around?
Yes, sir.
You've issued the notices for tomorrow at 9 a.m. Since we've got Ms. Williams up and she's on the West Coast, I think we may need to reissue calendar invitations to start at 10. Can you get that done? Do you think that's doable?
Yes, sir. That's no problem.
Okay, great. So we will reissue calendar invitations. Take a look. Be sure you catch the right one. We will resume again at 10 tomorrow morning. Ms. Williams, that's what we've done for you before. So I'm just assuming that it's going to be okay for you this time.
I appreciate it, but I will tell you, Commissioner, if you would rather start at 9, I'm prepared to do that, if that helps the commission. Seriously, I will do that.
A dangerous option, or are you sure you want to offer it?
Yeah, I will offer it because I know you guys are trying to get finished. So
I'm going to take you up on it.
Okay.
John McCoy. John McCoy.
Yes, sir.
Do not reissue the invitations. Let them stand.
No problem. No problem.
All right. We will resume again with Commissioner Brown-Bland at 9 o'clock tomorrow. And I want to thank you, Joanne, for staying late with us today. Appreciate it. See everybody tomorrow at 9.